না আমি আপনি কমপ্লিমেন্ট করুন।
আপনার
আমি একটা নোট তুলে বলছি।
May I be permitted mentioning very urgent because date fixed for preemptory hearing on tomorrow. Earlier, my
What is the impugned order?
yes, impugned order 17(3) was allowed. Consequently, 17(1) and 2
Compliance of seven.
because landlord file an application before the tenant rent controller that I am not a tenant. Kindly
What is the date?
tomorrow. Earlier there is no given time. That's why I'm mentioning before. Let it be heard tomorrow. Kindly.
Appearing in the list.
Yes. No.
It's not appearing.
Earlier appearing.
It's not appearing in the monthly. Some monthly list it is appearing.
Yes, ma'am.
Which item?
My lord, CO 305 or
Item number of the monthly list.
But I will
Hand over the slip.
yes. আমি দিচ্ছি
Inclusion on Wednesday. On Wednesday, unless it's extremely urgent, please do not mention.
May I be permitted to mention item number 130 of your lordship daily list?
Yes.
The next date before the London Court bill has been fixed on 21st of May. It's regarding to that sign binding matter. An interim order of injunction has been passed without having pecuniary jurisdiction of the London Court below. Necessary application has been filed, but that application has not been taken up. So government has already issued a term.
130 tomorrow. Note করে রাখুন একটা.
I'm sorry.
Yes. Yes, Mr. Banerjee.
My lords, kind leave Millard to file a revisional application without the certified copy. Millard 15, the impugned order was passed. Millard, we came to learn on Saturday, last Saturday. Millard, we have prepared it.
What is the extreme urgency,
Yes,
Mr.
there is
Banerjee?
extreme urgency. I just show your lordship, Millard, the urgency. Yesterday, Millard, bouncers came, Millard, to my premises at the instance of a tenant, Millard, who has, Millard, surrendered possession or in writing. Now,
What is the impugned order?
the impugned order says, Millard, status quo as regards ingress and egress. Millard, it's a wonderful impugned order. Now, Millard, on the strength of that impugned order, Millard, the tenant now want to, Millard, restore the possession. Millard, they are coming with bouncers. Millard, yesterday, Millard, they heckled, Millard, the lady
All right.
members of my family.
Leave to file, but you have the server copy.
Yes, server copy you have annexed.
With the file with the server copy, without the certified
And
copy.
Millard, may it appear tomorrow. Millard, we can't really wait. Millard,
Mr. Banerjee, you mentioned the date in the presentation form for listing. It will appear on that day itself.
so very grateful.
Yes, who is senior?
Kalke.
Yes, Mr. Mukherjee. 6:30 p.m. today. 6:30 p.m. today. 6:30 p.m. today. 6:30 p.m. today.
Saɗhe chhota.
Yes, Mr. Mukherjee, 6:30 p.m. Extreme urgency today at 6:30. Why? Today? Difficulty? Urgency, Mr. Mukherjee, you are saying urgency. I'm taking it up today itself. Where it is appearing?
I don't know why, but some file has been gone down to the department. Eviction has been sent, but it has been put on after eviction.
Cannot be done.
Not
What can be done, Mr. Mukherjee? So long you waited so long.
C10 mentioned, I can show the date for it. C10 mentioned eviction sent for it. Eviction sent. What all is it? Eviction sent.
Today itself. Slipটা দিয়ে নিন তো আজকে দেখে দেবেন 6:30 সময়।
My lord.
Yes, Mr. Mukherjee, hand over the slip. Hand over the slip.
My lord, may I be
Indicate the returnable date, Millard, as tomorrow, Millard, in the presentation form. Millard,
Mention that.
Millard, I need a leave from your lordship. Otherwise, department does not, Millard, agree to that.
Leave to be listed on tomorrow.
Tomorrow. If today, Millard, I leave it to your lordship. Tomorrow.
Today not possible.
Tomorrow.
Yes.
Tomorrow.
Yes.
Grateful.
This matter was earlier taken up by your lordship. At that point of time, the opposite parties appeared and prayed for time. Thereafter, the matter was never taken up, your lordship. Next date is before the London Trial Court is tomorrow for hearing of a section 151 application, your lordship.
Nothing will happen. Yes.
My lord, the commissioner has filed its report, the suit is proceeding.
All right, I will see that.
My lord, kindly, my lord.
Mentioning for lordship application for early disposal, suit filed by the wife for matrimonial divorce, lordship is pending from August 2019, lordship. And lordship next date is placed on the lower court on 21st May, lordship.
See what happens on 21st of May, thereafter mention. Yes.
Let-
Number 156, my lord.
Yes.
Matter, my lord, the execution case, my lord, the bailiff has gone to take the possession of my property instead of the suit property, my lord. I have filed on application that has been rejected, my lord. The next date is fixed before the lower court on tomorrow, my lord.
156.
My lord,
Tomorrow.
my lord, kindly consider, my lord.
No. Yes.
May I be permitted to mention, my lord, my lord, section 24 application, my lord. It has
Section 24 of what? CPC
CPC,
or
my lord.
CPC?
Yes, my lord.
What is the item number?
My lord, the item number is, my lord, 242, my lord.
Of the monthly or
Monthly list, my lord.
item number 242 for want of determination, let the matter. Please give the slip. Please hand over the slip. ওটা দেখে নেবেন for want of determination, let the matter go out of the list. Yes.
My lord,
To mention this matter, I am suffering interim order and I am filed
This
the
is on Wednesday. Yes.
My lord, today's item number 25, kindly make it not today.
Why? Why? Let it be called on. Yes.
my lord, may I be permitted to mention, my lord? Actually, my lord, I'm suffering from fever. That is why, my lord, I
Yes. Yes.
unable to. My lord, with regards to item number 533 of my lord's monthly list,
Yes.
urgency is, my lord, an application under order 6 rule 17 filed by the plaintiff was rejected, and thereafter, my lord, one application under, my lord, order 7 rule 11 filed by the defendant has been taken up for hearing, and date is fixed for, my lord, hearing of the application on 3rd of June, my lord.
Yes. Please wait. Yes.
My lord, the difficulty is, my lord, my junior is there, order is there, my lord. The
Yes.
trial court is not, my lord, granting any adjournment
Please,
in view of the.
please mention on Wednesday. Yes.
Extension of interim order, my lord, is expiring on the 30th.
Yes. Hand over the slip.
My lord, subject to the court, my lord. My retirement benefit has been stopped by the authority in view of the injunction granted by the court below. The fact is that,
What do you want?
my lord, the matter has appeared before your lordship under the heading of the returnable debt, but it has not yet appeared. My lord, item number 1238 of the monthly list dated 5th.
Please mention on Wednesday. Yes. Please, can you not wait till Wednesday? Wednesday is the date for mentioning. Yes.
113. What is the urgency? Planet could be a whole year.
Madam, you cannot wait till Wednesday. This Wednesday? I'm asking you, can
Fixed on 3/6/2025 during eviction, my lord.
when it is fixed,
3rd June.
3rd June.
so you can wait till Wednesday. Yes.
Lordship's leave having mentioned, your lordship, this was a revision application, your lordship, there was a Can 2 file for extension
You
of
do not wait till Wednesday.
extension, your lordship, the matter is listed today, your lordship.
Today
so
it
that
cannot
we
be done. Yes.
This matter was already, my lord, fixed, my lord, on 15th. My lord, I just tell your lordship, the urgency is that I have the sanction plan, but because of the, my lord, misleading the.
What is the item number?
My lord, 287 of my lord's list.
Yes. What do you want?
My lord, it could be, my lord, taken up, my lord, because my sanction plan is being frustrated, my lord, because of this.
Nothing will happen.
Caveator, we have served the caveat.
All right. Nothing will happen. There is a provision for renewal of the sanction plan. Yes, Mr. Bhattacharya.
For release. My lord appeared for the petitioner.
Which item?
1185 of the monthly list.
Calcutta will be mentioned. 1185, Calcutta.
1185.
Please hand over the slip. Call the list.
My lord, seeking your lordship's leave, my lord, seeking your lordship's leave to file the application without the signed copy of the order of the tribunal, arbitral tribunal, my lord.
Why?
The tribunal
What
does
is the
not sign.
urgency?
My lord, I just seeking the leave to file, my lord, not urgent. My lord, seeking the leave to file without the signed copy of the order. My lord, the arbitrator tribunal does not sign. He only sends by email and Word document. I've mentioned it in my application, my lord. Allow me to.
Show me that.
My lord, kindly takes. My lord, the second line in this page, my lord. I have mentioned it, my lord. The tribunal sends emails and Word documents, my lord. PDF is also not sent, my lord. Otherwise, I would have included, my lord, the signed copy of the order.
All right. Leave to file without the certified copy.
Instead of today, my lord, kindly takes up, today 6:30, kindly takes up tomorrow day after.
I've asked you, Mr. Mukherjee, to hand over the slip. Date I will consider.
Thursday is the day in the court.
You have said that today you have difficulty, then I will consider. I was thinking it was so urgent that you have to move today. That is why I was thinking that it can be taken up at 6:30. Yes,
I'm sorry, my lord.
yes.
Kindly recollect, my lord, this matter, my lord, caveator, my lord, purposely did not appear so that, my lord, this matter.
Please mention on Wednesday. Yes, call the list.
May I be permitted to mention one for non-prosecution?
Non-prosecution, give this. Yes.
I'm
Yes, call the list.
Party number 1.
My lord, the petition,
Why to be mentioned?
my lord, this matter was filed,
Yes.
my lord, matter was filed in February, my lord, but after that matter did not appear in the list, my lord. So, my lord, after mentioning this matter has appeared under this heading, my lord. My lord, petitioner is an unfortunate father, my lord, who was denied physical visitation of the child on special occasion.
Any caveat is there?
No, my lord. Whereas, my lord, on the prayer of the mother, my lord, the once in a month physical visitation duration was reduced from 6 hours to 1 hour. My lord, the impugned order starts at page, my lord. My lord, it starts at page 132 and the relevant portion is, my lord, at page 133. My lord, may I read out the relevant portion, the first paragraph, my lord. However, I do not find any justification to allow the prayer made by the OP for modification of the order dated such and such, and I am of the further view that such frequent visits as prayed by the OP, if allowed, will create inconvenience for both the petitioner and the minor child of the parties, and the education and co-curricular activities of the minor child may also get hampered, and the overall welfare of the child might get prejudiced. Now, my lord, kindly come to.
Where is your application for modification?
Yes, my lord. That application starts at page 127.
127.
Yes, my lord. This is an application made under section 25, application filed by the mother. Section 25 of Guardian and Wards Act, my lord. And my lord, I have seek visitation right on overnight access because it's a boy child, almost 10 years old. Visitation during Durga Puja, weekend, PTM, video calls. And my lord.
This by this order you have been permitted to visit the child on third Saturday of every month.
Every month.
Is it happening?
No, my lord. No, now, my lord, in this regard, my lord has sent an objection letter to the my lord that is annexed.
What was the original order which was modified?
My lord, the original order is at
19th of December 2023.
Yes, my lord.
Where
That
is that?
starts at 116, my lord. And my lord, relevant portion is at page 118. 118 at 119, my lord. The last para at page 118, my lord.
It was from 10 a.m. to 4 p.m.
Yes, my lord. That
So now it has been made
reduced to 1
for
hour.
1 hour.
Yes, my lord. And my lord, that too I am not traveling. Coming, my lord, the trial court will be closed. My
Without hearing the other side, how can it be done? The Next matter.
But to my lord, last page of the order, it will be civil judge junior division 5th court instead of 4th court.
Civil Judge Junior Division
5th court.
instead of 4th court. Any other correction? No other mistake. Ashun.
I am for the opposite party.
Yes.
But this is a matter, I'm seeking for extension of the identity order that has been granted by your lordship. But 7-2 pending, 7-1.
All right, I'm fixing it after the vacation.
Malos, there is a Supreme Court judgment which says for this type of application, Malos, stay should not be granted, Malos, and this should be expeditiously disposed of.
And the recent Supreme Court judgment, there is a reference made of all those judgments, Chamaria, Devashish Pal, all the matters.
But Malos, this is a settled principle of law. 7-1C stands on a different footing.
Have you seen the latest decision of the Honorable Supreme Court, wherein the Honorable Supreme Court has fixed the matter and has also appointed an amicus for the purpose of deciding this issue?
Malos,
With regard to the decisions you are relying upon, Amit Kumar Chamaria, Devashish Pal.
Malos, 7-1C is on a different footing. Amit Kumar Chamaria is for Malos 7-1 that admitted rent should not be disposed, should not be Malos paid beyond Malos 30 days.
Have you seen the latest Supreme Court judgment, wherein the amicus?
That is regarding Malos.
All right, I will hear you.
Within
I'm only extending it for a limited period.
Malos,
I will hear you. I will hear you.
And Malos, kindly see this judgment of the Supreme Court once, Malos. This is on Malos 25 April 2025. Malos, this is the Malos second paragraph. Owing to the interim stay of the proceedings filed by the petitioner applicant herein, there is no progress in the trial of the eviction proceeding. In the circumstance, petitioner's counsel sought for a direction for expeditious hearing. Although we are mindful of the fact that there may be hundreds of petitions pending before the High Court, nevertheless, we are constant to observe that where the High Court has stayed the trial in cases, particularly pending between landlord and tenant, those cases must be heard expeditiously in as much as the stay of trial or the original proceeding would inevitably.
That issue is not germane in that matter.
Malas, stay has been granted. Malas, that is why I am saying.
Stay has been granted, which goes to the root of the matter.
And
the defense will be struck off if the stay is not granted.
Yes, my lord. That's so. And this is also a fact. My lord, third paragraph, your lordship seen. Learned counsel for the petitioner sought for striking down the defense owing to.
Sir, I will hear you just after the vacation. Please undertake that you will not proceed with the hearing, or everything will be reversed there. Let us suppose if the order is set aside, what will happen? If you have parties have to be relegated to the position it was earlier. Yes, next.
But same matter, Mullah. Different.
You are appearing, same order.
Affidavit of service gulo rekhe deben.
Affidavit of service filed in court today is taken on record. আচ্ছা ওটাতে লিখে দেবেন the opposite party.
Great.
5 with 7.
We are
But in
appearing.
this matter, I am
This is why
appearing,
fairness, Mr. Banerjee.
Yeah, this is a matter, my lord, where
but in this matter, I am appearing on behalf of the opposite party number 1 and 2. I just received the Vokalatnama and the yes.
pure question of law, my lord, it will take hardly a second's time, my lord, for your lordship.
But
My lord,
Mr. Banerjee, your learned friend has received the copy just.
my lord, I just indicate, my lord, the issue. I just indicate the issue. Then, my lord, I leave it to your lordship. My lord, a suit, the value of which is, my lord, 1,65,200.
Sir, have you gone through the order dated 7th of May 2025?
No, my lord.
Please go through the order. When do you want?
At present, I have no brief, my lord. I already.
Mr. Banerjee, you have got the instructions.
We can come back,
Yes,
my lord, in the second
I
half.
got instruction.
Please.
Please, my lord, will solve here and now.
Well, let it be fixed on 22nd May, my lord.
22nd.
May. Otherwise, after vacation, my lord.
My lord, only one point, my lord, will argue.
21st, you have difficulty.
No, my lord. 26 as per instruction, my lord, let it be fixed on 22nd May, my lord.
My lord, on the fixation of date, my lord, there can't be any instruction as such.
Kindly consider.
I'm fixing it on 21st.
Well, let it be fixed.
Yes.
My lord,
5, 6, and 7, same thing.
Yes, yes. Same.
Yes.
My lord, the affidavits of service, my lord, do you have?
Affidavits of service filed in court today is taken on record. Call the next matter.
Grateful, my lord.
Grateful, my lord. Grateful, my lord. Interim order is expiring on 31st of this end of
Sir,
this.
this is not the way of mentioning, sir.
I have already
Sir.
matter is appearing under the heading contested.
Yes, call the next matter.
Contested application, my lord.
Next matter.
It I accepted for the petitioner.
Please maintain some decorum. It's not the time for mentioning.
My lord, wife is the respondent in the suit for divorce. My lord, my application for recall of evidence has been turned down on a technical ground that it was not supported by affidavit. My lord, husband has given a cross.
What is the reasons for recalling of PW1, Mr. Banerjee?
My lord will see, my lord, what has actually happened. My lord, only one cross-examination done.
Mr. Banerjee, do you know only one sentence cross-examination may be sufficient in a case?
Yes, but my lord,
one or two questions may be sufficient.
My lord,
The more
just
you
see-
cross-examine,
my lord, just
the
sees
more
the-
your case will be demolished. There are instances, the more you cross-examine, the more your case will be demolished.
My lord, suit.
So there are instances when only 2 or 3 questions are put. That is sufficient.
My lord would see these are
Demolish the case of
these
the other side.
questions are absolutely
That's the art of cross-examination, Mr. Banerjee.
absolutely, my lord. But my lord would kindly consider only, my lord, these are only formal questions that had been asked by the erstwhile counsel. My lord, see, this is the cross-examination, my lord, it's marked, my lord. Suit for divorce on the ground of cruelty and desertion, my lord.
It's very difficult to read, Mr. Banerjee. PW1.
PW1. This is the husband. Only these questions have been asked. And whereas my case is that the husband was diagnosed with and I must be very candid with your lordship, the application, my lord, does not disclose also. But difficulty is this, my lord, the client will suffer. This is
application, you have not stated on what points you want to cross.
But kindly see page 63 once. Page 63 of the application. Well, what is there on record? I cannot go out of the record. But this is the actual state of affairs, my lord. The litigant will ultimately suffer. And this has not been supported by any affidavit, anything. And since, my lord,
what I can do, since if not supported by an affidavit, I can give you leave to file a fresh application.
Yes, my lord, kindly grant me. And this was the only consideration before the court, that since it is supported by affidavit, no, it is not supported by affidavit, therefore. But a client, my lord, it's not possible for them to know these nitty-gritties of law, my lord.
Nine.
Yes.
My lord, petitioner,
Yes, what do you want?
my lord, only High Court direction, my lord.
What High Court direction?
Speedy disposal for, because only the defendant.
What is the stage of the suit?
Suit is the order 39 rule 1 and 2 as absolute, and the main suit
Suit is at the nascent stage. It's at the nascent stage. Written
starting of
statement
the
has been filed. Written statement has been filed. Issues have been framed. No.
last order on 24 to 25.
The injunction application is still pending.
No,
The injunction has been disposed of.
disposed of. Order
This
39 1 10 I am appearing on. 10 হ্যাঁ আরে হ্যাঁ 10 হ্যাঁ দিলীপ মোদী
Yes, what is this application?
my lord suit is pending till
Also expeditious hearing.
yes same here is the plain petitioner is the plaintiff number 5 and suit for partition and
Plaintiff number 5.
plaintiff number 5.
Where are the other plaintiffs? They have not joined.
No, that is only plaintiff number 5.
Can the plaintiffs file civil division application separately? Some coming, some deciding not to come. Can that be done?
No, my lord. They are not interested, but plaintiff number 5 is the
You
interest.
have to have taken steps in the learned trial judge for that. If other plaintiffs are not
Because it
willing
is
to
a
proceed.
my lord partition suit, my lord, and no
There are provisions for that if the other plaintiffs are not proceeding. Ashun, this
But I have made a correction that
yes.
is pending before the senior division Barhampur, Murshidabad, only for my lord expeditious hearing.
Expeditious hearing, what is the stage of the suit? You have not annexed any order sheet.
Next date fixed for hearing, my lord.
Where is that? No document. Nothing.
My lord, I obtained the information slip, my lord. This, my lord.
This application under Article 2
I am for the petition.
Yes, Mr. Chatterjee.
My lord, I SL the order passed by the learned district delegate Howrah in a suit for succession. Lordship, I am the opposite party there, being the widow of the late Shorit Shekhar Das, who died. Now,
Who has applied for succession
uh,
certificate?
my mother-in-law. Now, this is pending. My lord, I made an application in view of the recent amendment of Section 39 of the Insurance Act 1938, seeking the segregation of the insurance claims, LIC, where I am the nominee. I've been shown as the nominee. Because in view of that amendment, Lordship, that Section 39(7), which has changed the earlier position in respect of the nominee who was the receiving nominee. Now, this is beneficial nominee has been introduced by virtue of this amendment. Now, earlier the position of law was, subject to correction, my lord, was that nominee was considered to be the mere receiver of that money. But now he is a
The
beneficial nominee.
succession certificate proceedings only for LIC policy.
Apart from that, the bank accounts are
So,
there. Now, learned
Mr.
trial
Chatterjee,
judge
how
should
the
have
succession certificate proceedings cannot be
segregated these two and allowed us.
That was your prayer. That was the
Lordship,
prayer for
kindly come,
segregation.
kindly come to my. My lord, kindly come to my application once.
Yeah.
My application, which is in page 14, page 13. Page 12 is the prayer. Now here the instant application is not maintainable and being barred under the provisions of Section 39(7).
Oh, Mr. Chatterjee,
39(8).
if the succession certificate proceedings contains other certificates also, the entire proceedings cannot be held to be
I'm not
maintainable.
also seeking that, Lordship.
That is your prayer.
Yeah, that learned judge should have.
That is your prayer.
Lordship, if I make that application to that effect, that these things should be segregated.
And what is the status of a nominee, Mr. Chatterjee?
Lordship, kindly come. I can satisfy your Lordship on the basis of this. Kindly come to the amendment once, Lordship. Section 30.
Amendment says that the nominee will become the owner and the rights of others will go.
That is the change in the law, Lordship. My
So,
39.
So, Mr. Chatterjee, if you are entitled as per the law to segregate, because this was for maintainability, you will be at liberty to file an appropriate application.
An application that may be disposed of. Lordship, I also would like to rely on one judgment of the Honorable Delhi High Court. The same thing happened, and Lordship, as it has fallen from correctly.
Rely before the learned trial judge, not here.
Your Lordship, that
this application under
Appear for the petitioner.
Item number 30 will have instructions to appear.
Yes,
For the opposite party, there was a caveat, I believe.
there was a caveat. You have not served.
1564. Well, I was instructed by my clients, my lord.
Well, there was no caveat. We have
There have been a caveat 156.
we have checked it from the department. My lord, they say there was no
If
caveat.
there
That
has
is
been
why I have not
commonly
served.
served upon me.
Yes, what is the impugned order?
Yes, Your Lordship. The impugned order is of 12th of March 2025. My lord, a brief fact.
12th of March 2025.
Yes, Your Lordship. Lordship, the brief fact of the case is.
Madam, have you annexed the entire certified copy? Please check up.
Well, this is what we could obtain, but we feel that there was one another page. We have tried.
Last page, it starts from par contra.
Per contra, that is the question, my lord, that we also had it in mind, and we have tried connecting the clerk of
Please
the
file with the certified copy. Give him a copy.
Lordship. A little urgency.
I'm for the petition, madam.
Yes.
Madam, expeditious disposal of the proceedings in connection with the title to number 264 of 2019, madam.
Injunction application is still pending.
Yes, yes, madam.
This application under Article 227 of the matter.
15.
Yes, Mr. Rai.
Petition is directed
Please use the microphone.
for expeditious disposal of the title suit pending in the second court, Bar 1. We are the defendant. We enter appearance in the
What is the nature of the suit?
suit is for declaration of the exchange deed made between the municipality and the petitioner to be declared fraudulent and void.
Temporary injunction application is pending.
Injunction, initially they obtained the
right.
injunction order on our appearance. It
This
is vacated.
application
For passing an injunction, because after vacation of the interim order, they sought to create the third party interest, for which he made an application for passing an injunction order.
But the suit is yet to be made ready for hearing. as it appears from the,
17.
not at this stage. Let
But
the
your
suit
lordship
proceed to
kindly
some
continue,
extent.
please.
This application under
As possible. Your lordship kindly indicate.
yes, next.
Madam, I beg to appear on the petitioner, madam.
Yes.
In this matter, madam, I am challenging the order of maintenance passed in section 24 applications, my lord. My lord, kindly see, my lord, in a wife initially filed an application under section 125, and in the affidavit, kindly see, my lord, page 21 once, my lord.
Page 21, yes.
Yes, this is the affidavit filed by the wife.
Yes.
Column page 22, para 5.
Page 22,
para 5.
yes.
Kindly see. And my lord, on oath, my lord, this 125 application is withdrawn. But in the thereafter, my lord, petitioner filed an application for dissolution of marriage on 1st of August 2022. Wife filed a section 24 applications. On 6th January 2025, she filed a maintenance amendment application on 6th January 2025, and that has not been mentioned in both on our application that she has withdrawn the application section 125 on that ground. Both two applications I have annexed, my lord.
Yes.
Nowhere it was mentioned that she filed that and she has withdrawn. And
What she has withdrawn?
yes, my lord, 125 application. But that should be mentioned in the section 24 application.
If they withdraw an application under section 125, is it a bar to grant maintenance?
No bar, but the averment should be there, my lord. And kindly see, my lord, there
I accept that averment should be there. Show me that she is not entitled to alimony.
Well, on this issue, my lord, on Karnataka High Court judgment is there. If the adultery is proved, my lord,
where adultery has been proved?
On affidavit, my lord, that is why, my lord, kindly consider one aspect, my lord. The law is that from the date of filing, 1st of August 2020.
Where is the adultery proved?
On oath, she said that. On oath, she said that. On oath, she said, my lord.
Is it a bar under section 24 of the Hindu Marriage Act? Show me.
No, I have seen in Domestic Violence Act, I am not.
I'm asking you section 24 of the Hindu Marriage Act. Show me.
Kindly consider, my lord. Well, only one another thing.
After some argument, if you are ready, yes, or I am adjourning it. After some argument, the learned advocate.
On next date,
it will appear in the list. Yes.
I'm appearing for the petitioner. First, the instant application for expeditious disposal, my lord, at the instance of the wife plaintiff petitioner. Right? If your lordship kindly take up, there is not the first time. If your lordship kindly take up at page number 16, there is a mandatory order of this honorable court. Page 16. Order in portion is at page 17 last week, having heard the London Council appearing for such and such. Thus, while this court does not entertain the prayer for transfer, this court mandates the London Additional District Judge, 4th Court, Barashat, shall dispose of the matrimonial suit as well as this is a miss case for for matrimonial suit as well as the miss case for custody.
So this is the matrimonial suit you are saying?
Yes. And now I am praying for the it's
Expeditious hearing of the matrimonial suit.
There is a
This
mandatory
application
direction.
under. Yes.
For the opposite party. Defendant is the petitioner before lordship in a suit for eviction. Lordship, before lordship goes and sees the impugned orders, there are several impugned orders. Lordship, I will hand up a list of dates which may.
What is the impugned order?
My lord, petitioner is primarily aggrieved by the order of dismissal of an application under 7.2, not on merit, but on the basis that I have not complied with the 7.1 application. Even though the application for 7.1 for condonation of that period was pending before the learned trial court.
Mr. Mukherjee, what is the dispute? Senior Mr. Mukherjee, what is the dispute in the 7.2 application?
Said the quantum of rent, admittedly, they sought amendment of the plaint. That quantum of rent is wrong given. And secondly, the period of default.
Both are in dispute.
Both are in dispute. And in fact, in written statement.
What is the admitted amount? Have you deposited the admitted amount?
Accepted by them. Paid and accepted by them.
No, I'm asking you, have you deposited the admitted rent at the time of filing of an application under section 7.2?
My lord.
Show me your application under section 7.2.
Lordship, I have handed up the list of dates.
List of dates I will come. Please come to the section 7.2 application first. 7.2 application page.
Lordship, at page 62, Lordship kindly sees the 7-2 application. It is handwritten, my lord. The defendant strongly denies the fact that there are default.
How many orders?
Yes, my lord. Since Lordship kindly sees paragraph 2.
Where is the 7-2 order, Mr. Mukherjee?
7-2 order is at page, the impugned order of 4th of 3rd.
No, impugned orders are many. Please come to the order passed under section 7-2.
Yes. No, एक minute. Lordship, 4th October 2023 order.
4th October 2023.
Yes.
You are challenging now, Mr. Mukherjee.
Several orders have been challenged. I'll tell my lord what is the fact. Lordship,
you can challenge from order number 1 to order number 58 in one application.
Lordship, I am a school.
5 years, maybe you are a school. I am asking you, can you challenge any number of orders?
No,
which
ought not to have.
Then
ought not to have.
What do you propose to do, Mr. Mukherjee?
Lordship, I will limit myself to this first of 4th October 2023 order.
Where is your explanation for the delay with regard to this application?
Lordship, even though I would say that in 227 no explanation is required.
There is a decision of our court.
Yes. Some
explanation for the delay.
Explanation for the delay should be there.
Show me where is the explanation for the delay so far as this order is concerned.
It is not there.
Then, Mr. Mukherjee.
It is not there, but Lordship kindly comes to the nature of the order at internal page.
So this is the order which you are really aggrieved against.
Yes, because Learned Trial Court has not gone into the merit of 7-2 and rather disposed it of, dismissed it on the ground that I have not complied with the 7-1 order.
Where is your 7-2 application?
62. Lordship kindly
show me the disputes raised there.
Lordship kindly comes to the plaint. The plaint is they sought the eviction solely on the ground of default. Lordship kindly comes to page 47. Lordship kindly comes to page 40.
Mr. Mukherjee, give me a minute.
Just a minute.
Till which month you have paid the rent?
As on today, up to date.
As on the filing of the application under section 7-2.
As on the date of filing of the application, I had paid rent up to August 2017.
Up to August
2017.
And
in the plain declare.
So when did you file this application under section 7-2?
That is not in dispute within 1 month.
But I'm disputing
that. So Learned Trial Court,
Mukherjee will be getting your chance.
My friend is saying that there is no dispute.
Let him say that there is no dispute. So
Lordship,
August 2017, according to you,
Lordship kindly comes to page 40,
and
just a minute, my lord, page 47. I'll show the dispute.
Mr. Mukherjee, please, one. What is the date of filing of the 7-2 application?
Date of filing of 7-2 application, but that's what I refer to the list of dates. I filed
the date.
6th February 2023.
6th February 2023, 7-2 filed.
Yes.
So, at that point of time, when you filed 7-2, so rent from August 2017 to February 2020 to January 2023 was in arrears.
Yes.
Did you deposit that amount along with 7-2?
No, I did not.
End of the matter, Mr. Mukherjee.
I did not. I only sought depositing the current rent.
Cannot be done. 7-2 admitted rent, you have to deposit.
And thereafter, I tendered the entire rent to my learned friend's client and he accepted it.
Thereafter means?
Lordship kindly comes to page 71. 71. on 2nd December 2023,
After dismissal of 7(2).
After dismissal of
7(2).
they accepted the entire rent.
at the time of filing of this application, admitted rent amount was not deposited.
Yes.
I'm deciding 7(2) on merits here.
Lordship may.
Yes,
But
but what is there?
Lordship
What
kindly
more is there? Mr. Mukherjee, statute requires you to deposit admitted rent along with the.
within 2 months.
Yes.
After within 2 months after getting an opportunity of hearing.
No.
7(2) has not been decided
No.
on merit.
Admitted. It's admitted. From August 2017 to January 2023 is admitted.
Lordship,
Mr. Mukherjee,
Lordship, the point is,
7(2), there is two things.
yes,
What will be adjudicated? The dispute will be adjudicated.
and the relationship.
Yes.
Dispute
You have also disputed the
in
relationship.
written statement, yes, I have.
Show me 7(2).
7(2), I have not.
Then end of the matter. But 7(2), you have not raised that point. Written statement subsequently may have
I
raised.
have raised that point, the relationship.
May have, but 7(2) there is no dispute.
In
Only a dispute with regard to the rate.
I cannot rate of rent and the period of default.
Show me the period of default you have
Yes,
dispute.
that's what I wanted to show. That's
Show
what
me
I-
from 62.
Lordship kindly comes to page 47.
Not from 47, 62, 7(2).
Lordship has seen 47.
7(2), show me the dispute raised.
At first 47, what they stated in the plaint and what I have stated in 6(2).
Yes.
7(2).
Yes. 47.
Paragraph 10.
Yes.
Grounds for eviction.
Yes.
That the defendant is a habitual defaulter and the defaulted in payment of rent since October 2015.
Yes.
That is their allegation, and the only ground taken in the eviction suit is the default. And now Lordship kindly comes to page 6. And what is the rate of rent? At page 47, 362.25.
Yes. 365.25.
At paragraph 12, it is 365.25. Yes.
Yes.
365.25. Lordship now kindly comes to page 62.
Yes.
It says that the defendant strongly denies the fact that they are defaulter of the payment of rent since October 2015. The defendant further denies that the monthly rent of 365.25, but actual rent is 356.25.
So according to you, 356.
And they accepted that, amended the plaint.
Yes. Yes.
The defendant here.
Mr. Mukherjee, one thing. Their claim is 365. Their claim is default since October 2015. Your claim is 356. Your claim is you have paid till October 2017. So admittedly, you are a defaulter at the rate of 356. According to you,
yes,
from November 2017
till the filing.
Till January 2023.
Yes.
Have you deposited this amount at this rate?
I cannot till it is adjudicated.
No. That is not the law. Please come to 7(2).
Adjudication is required.
No.
When
Mr. Mukherjee, adjudication is disputed. But you have to deposit as admitted by you. Dispute will be adjudicated. Admissions need not be adjudicated, Mr.
Lordship,
Mukherjee.
kindly 7(2).
Yes.
If in any suit, Lordship got it?
Yes.
Lordship knows it by heart.
No. You can place. I will hear you while you are placing. Yes.
If in any suit referred to in subsection 1, there is any dispute as to the amount of rent payable by the tenant shall, within the time specified in that subsection, deposit with the civil judge the amount admitted by him to be due from him, together with an application for determination
Yes,
of the
so
rent payable.
admitted amount has to be deposited.
Yes.
So admitted amount is 356.25 from November 27 till January 2020.
My lord,
admittedly not deposited.
My lord, this suit is coming from the Presidency Small Causes Court. In the Presidency Small Causes Court, the system is, unless there is an order of the court, I cannot deposit the rent. Unlike the other courts. And no such deposit shall be accepted unless it is accompanied by an application for determination of the rent payable. On receipt of the application, the civil judge shall, having regard to the rate at which the rent last paid and the period for which the default may have been by the tenant, make as soon as possible within a period of not exceeding 1 year an order specifying the amount if any, due from the tenant, thereupon the tenant shall within 1 month from the date of order pay to the landlord the amount so specified.
What is,
So
according to you, the interpretation of 7.2? Please tell.
Therefore, when
So if you raise a dispute, you need not deposit anything. After adjudication, you will deposit.
My
That
lord.
is the sum and substance. Anything more, Mr. Mukherjee?
No, my lord, I will also, Your lordship knows that both the Chamaria and Devashish Pal is now before the special bench. That is under,
Your case is not on that.
my case is not on that, it is on this thing. Now, lordship, there is a
What
judge,
is the point there?
the point there was 7.2, section 5, whether there is applicable, this is
So
not a section.
according to you, you are within time. So that decision cannot come to your aid.
The court has held the time within time.
So that decision cannot come to your aid.
And lordship kindly sees my lord Justice Chaudhury's judgment. It's an unreported judgment.
Per incuriam.
Per incuriam has been held by
It's
Justice
per
Mukherjee.
incuriam.
Justice
Did not take note of my decision given earlier.
That has been held by Justice Mukherjee, that is per incuriam.
Per incuriam. Did not consider 2 of my judgments delivered earlier. Please don't invite the observations of the court.
No, I will not.
You know it very well, Mr. Mukherjee. So
I will. No, 7.3 to adjudicate. Should have referred to the latter.
yes, where is the order under section 7.2?
Lordship kindly comes to page impugned order dated 4th October 2023.
4th October 2023, yes.
Yes. Impugned order. But you've got it?
Yes. Yes. What is the defect, Mr. Mukherjee?
Lordship kindly says that 7.1 has been 7.1 application has been I had filed, there was an order.
The 7.1, Mr. Mukherjee.
7.1
In a case, Mr. Mukherjee, in a case where there is a dispute, 7.1 does not lie.
Yes, but 7.1 was filed by my client saying that allow me to deposit the current rent. There was
That's current.
Current rent.
Yes, current it's other thing with regard to the admitted areas. Admittedly not deposited. Admitted areas, admittedly not deposited.
Now what will happen?
To admission. Admitted areas, not admittedly deposited.
Yes, admitted at the time of filing of the 7172. Now lordship kindly comes that ordering portion.
Mr. Mukherjee, if you want to make at length argument, I can post it after the vacations without any stay, anything.
No,
We'll proceed.
the matter was there today before the learned trial court adjourned.
Trial court?
Trial court adjourned it today.
I will say that pendency shall not be a bar in proceedings. You can make your arguments at length after the vacation because this is a well settled proposition. Even then, if you want to.
Adjudicate finding. They have filed 2 section 7.3 applications.
Not required. Automatic. After this is automatic. But even section 7.3 is not required. It's an automatic under the statute.
But even if my written statement is already on record, written statement accepted. Now,
you know the law, Modula India.
Yes, I will be allowed to cross-examine.
That is the other thing.
If I am able to prove that the default is already satisfied.
Yes.
Then in the trial it will.
Waiver on the ground of default, what you are trying to say.
Yes.
I have also decided that issue in one of the matters.
I have seen that judgment. I've seen that judgment. That will come to some extent in my.
That is why. So, waiver of the
because what has
ground of default.
Well, what has happened?
Whether it comes to your aid or it comes to the head of other Mr. Mukherjee's client,
That will be in the trial.
that will be in the trial. Ashun. This application under Article 227.
So therefore, my lord, 7.2 is not on merit. 7.2 is in view of my default in
I'm giving
to pay 7.1.
I'm giving reasons for that. This application under
Nowadays, the tenant and the husbands are the bad words.
I'm coming after 5 minutes. You can take back the list of dates that may be of some use in other proceedings.
19.
I'm for the defendant petitioner, my lord. Plaintiff had obtained an ex parte ad interim order of injunction on 20th of September 2024. Plaint not served, injunction not served, order not communicated. I get to know of the order on January 2025. I file an application for vacating on 18th of February 2025. The
39 Rule 4.
Yes. The learned judge on 18 February 2025 fixes the hearing of my Order 39 Rule for an injunction application on 24th of July 2025. This is in teeth of Order 39 Rule 3 capital A, which requires, my lord, an ex parte, whenever an ex parte order is passed, to do it in 30 days, and if not done in 30 days, to give reasons to be recorded in writing as why it is not done. On 24th
It's an
of July.
appellable order.
My lord, I'm only, my lord, in respect of this direction of the learned judge fixing the matter on after 5 months. This is, my lord, Order 39 Rule 3 capital A, my lord. My lord will kindly see it's completely in the teeth of it.
What do you want me to do now?
My lord, kindly, my lord, directs, my lord, the learned judge to give liberty to prepone the date.
So that you have to apply there.
Yes, I'll make it. Or, my lord, by 24th of July, let everything be decided. Because 24th July.
That I can.
Yes. Let, my lord, my vacating an injunction.
24th of July.
On July. My lord, the impugned order is at page 76.
This application under Article 2.
I'm challenging an order passed by learned ADJ Bonga, my lord. The petitioner husband instantly filed an application under Section 9, restoration of conjugal right, my lord. Thereafter, the wife filed one application under Section 24 of the maintenance. I appear in the said matter, my lord. Thereafter, the ex parte order was passed by the learned trial judge, my lord. Kindly come to annexure page number 27, my lord. The application under Section 24, my lord. And I am referring page number 28. Kindly see page para 3, my lord.
that at the time of marriage, OP introduced himself as an employee of the police service, government of West Bengal, my lord. Thereafter, kindly come to my lord, page number 30.
Yes, what is the order? Please take me to the order under challenge. Yes, where is the order under challenge?
Order is, my lord, in certified copy, my lord.
Yes,
Kindly
yes.
an interim order and maintenance order directed to pay 15,000 per month. My lord, kindly come to one.
Yes, yes. 15,000 per month.
Yes, my lord, kindly come to page 66 once.
Yes.
I annex the pay slip, my lord.
This is the order of 6th of August, 6th of October 2023.
Yes, my
Why are you challenging at such a belated stage?
My lord, kindly consider the order is passed ex parte, my lord.
Maybe. Why did it not appear?
My lord,
You said that you contested this
yes, my
application.
lord, I have.
Why did it not appear?
Yes, my lord, kindly come in page. I have filed 3 applications.
What steps are you taking in your matrimonial suit?
Yes, my lord. That
In
is
your
pending, my lord.
Yes, yes. What steps? Order dated 6th of October, you have not taken steps in your matrimonial suit.
My lord, kindly come to page. Kindly come to page, my lord.
Sir, you are not taking steps. You did
My lord,
not
kindly
appear
come to page.
either in your matrimonial
My lord,
suit.
kindly come to page 74, my lord. Kindly come.
Where is your explanation for the delay? I will not allow you to move this application
My lord, once
at such a belated stage.
kindly comes 174, page 74, my lord.
Yes.
The ex parte order, interim order was passed. Thereafter, my lord, kindly come to 78, my lord. I have filed 2 applications for vacating the ex parte order and 150 and 1 application for recalling the order dated.
What happened with that?
That was not disposed of without this here.
When did you file that application for vacating?
My lord, on 9, order number 6, my lord, kindly page
Order number
6. Kindly come to page 78.
78.
Yes, my lord.
Yes.
To the bottom, my lord.
Yes.
Case record is put up by the respondent, husband, put up petition including 2 petition WO asset liability by swearing affidavit. Learned PO is on leave today. Learned sub-judge senior division, Bongao in charge of the court, heard the submission. The put up petition hereby allowed and kept in record. My lord, kindly come to next page 79. My lord, today fixed for hearing of the appearance of the party. Both the parties along with their learned lawyer physically present. I have gone through Miss Case 24 Hindu Marriage Act, filed the petitioner wife, namely such and such. It is mentioned therein that Miss Case number 22 arising out of such and such. Respondent in the instant case filed 1 pay slip, Government of West Bengal Home Guard Organization. Pay slip justifies his income in respect of Miss.
Yes, yes, you are not appearing.
Yes, my lord. I am in the
Order sheets, it appears you are not appearing.
Yes, my lord.
16th of January 2022, please come to the order dated 16th of January 2022.
My lord, I have filed thereafter.
Maybe you have filed, but you are not appearing.
My lord, those applications are not disposed of by the learned.
Maybe.
Kindly come to this order, my lord.
Maybe.
Once 79. Thereafter, my lord, kindly
Show me when did you move this application for vacating. Show me the date when you moved this application.
16th January 2022, my lord.
Yes.
Kindly come.
Both the parties, after going to the appearance, the petitioner was also absent on 27th of July 2024. We were absent.
No, my lord. The respondent husband also filed 1 petition 151 for recalling the order dated 2nd September.
Yes, what are you doing?
Yes, after filing that.
What is your income?
16,000. My lord, kindly
16,000. Where are you engaged?
Home Guard, my lord. Kindly come to page 66. I have annexed the pay slip and also give the pay slip before the learned court, my lord. It is recorded in the order, page number 79, my lord. That one pay slip has kindly come to page 66. I have annexed the pay slip.
seen. Your conduct is not very good.
My lord, the wife is also
All right,
in.
that will be seen. Please comply with the for the present. Thereafter, it can be adjusted. Please show your bona fide by paying something at least.
Yes, I have paid already. Kindly come.
All right, all right. That
Yes,
will
my
be
lord,
seen.
kindly page.
That will be seen. Yes.
My lord,
Next.
kindly come to page
If you
one.
if you have paid,
1 lakh I have paid, my lord.
all right.
Kindly,
If you have paid,
my lord, kindly comes to page
there
one.
is no difficulty. You go on paying. There is no
No, my lord,
difficulty.
kindly comes.
Just call the next matter. Call
My
the
lord, kindly comes to page 107, my lord.
June.
My lord, kindly comes to
Yes.
page 107, my lord, once. The High Court.
Yes,
order,
you have paid. There is no difficulty. Yes. If you have paid, there is no difficulty. Go on paying.
Yes, 21, my lord, I am the petitioner. The petitioner and the opposite party both are the own brothers.
Yes.
The father of the petitioners and opposite party gifted two number of house in favor of their name. However, the opposite party forcibly entered one of my house, one room on the ground floor. Therefore, I have filed a suit for eviction. And within time, he failed to file a written statement. However, written statement has not been accepted. They prefer 227, the Honorable High Court was pleased to direct to accept the written statement subject to payment rupees 10,000 cost, and here this dispose of the matter within 1 year. Thereafter, my lord, the evidence of the plaintiff is been concluded, PW1. The defendant took adjournment on several occasions. Thereafter filed a suit for partition before the division bench, before the senior division, first civil judge, senior division, in the same court. And the suit for eviction, the civil judge, junior division. Then, my lord, what happened? He filed section 24 before the learned district judge, as because the partition suit application is pending before the learned senior division, let this matter be transferred to the senior division. Accordingly, after contested hearing, the matter at this stage transferred to the senior division. Hence, this revision application, my lord.
It's better because both the suits are interlinked. If it is tried analogously, it's better.
No, my
Why
lord,
are you aggrieved by that?
my lord, the suit for eviction on the ground of trespass has been filed in the year of 2018.
Trespasser or licensing?
Licensing.
So-
Licensing. My lord,
So
kindly
you are
hear me.
claiming your who is the opposite party, your brother.
Brother.
So you are claiming your brother is a licensee. Brother claims the both of you are co-sharers. He has filed a
My lord,
he has filed a suit for partition.
suit for partition. My lord, kindly.
That is to be decided. Otherwise,
My
there
lord,
will be
kindly
conflict of
no, my lord,
decisions.
my lord, kindly hear me for a moment. My lord, he is admitted the father gifted two numbers of house. There is another property is there. They have accepted the gift.
Those are on merit, sir. So if there are two
But
suits,
when the Honorable High Court was pleased to direct to dispose the matter in the specific period, my PW1 is already been completed. Only 2 days are required. One is evidence of the DW1, then argument. At this stage, at the filed the 2023, the partition suit has been filed. 2023. And my lord, the suit for 2018, eviction suit 2018, only 2 days are required.
what is the number of your suit? Title suit number 412 of 2018.
My lord, kindly for a moment.
What is the number of your suit?
412
of 2018.
Yes, 2018. 214/2018. And it is wrongly typed more, it will be 24. Suit for title suit number
230 of 2024.
24. It's a wrongly printed 3.
All right, what is the stage of that suit?
So, it is initial stage, just initial stage, the partition suit. And in so far the eviction suit is concerned, the PW1 is been completed as per direction of the Honorable High Court's order. Kindly see for a moment the Honorable High Court's order, my lord.
All right. The petitioner is aggrieved by the order.
Sir, my lord.
Then this will be allowed. Then this will be allowed, cannot be done. Then the civil division will be allowed without hearing the other side. If it is stayed and will proceed, suit will be decreed. Please apply your mind before making this prayer. Yes, next.
I'm grateful.
Next, whatever became infatuous, my lord.
22, when have you filed and when it has become?
My lord, on
14th of May, you have
yes,
filed.
my lord, the 15th, my lord, execution has been completed, my lord.
The learned advocate appearing for the petitioner submits that
For the petition.
yes, Mr. Rai.
My lord, my application for vacating an ex parte proceeding has been rejected.
Rightly.
No, well, kindly, yes, my lord. The date of hearing was fixed, my lord. My lord, this is a proceeding under Order 9, Rule 13. In that event, my lord, if you
Not Order 9, Rule 9, it has been recorded as order.
no, Order 9, Rule 13, but it's misprint possibly. Now, my lord, on 20th December, my lord, suit was fixed for hearing. On that date, my lord.
That is not very good.
No,
You
my
are
lord,
appealing for the other
that is
side.
that is what is reflected from the order, but may I explain it? On 20th November, date was fixed for hearing.
Entire order sheet, your lordship will see the conduct.
No, may I place it? Why this misunderstanding? On 20th December, date was fixed for hearing.
How much cost you are willing
Well,
to
kindly, but
I'm asking you.
Mr. I cannot.
No, don't give to the court. I'm asking you. How much cost you are willing to pay to allow your client to
what has gone
to the relegated to the position as on the passing?
In that event, my lord, kindly, my lord, allow me to, my lord, place, my lord,
Then it may be a different
chronology of the case. No, I will not on the minutes.
You go to the chronology, it may be a different case.
Your lordship, my lord,
It is not even a fit case for imposition of cost.
No,
for us.
I
That is why I'm asking you.
Before, my lord, hearing, my lord, the merits, my lord, not cost, my lord.
Then my mind may change. You can.
My lord, if your lordship preempts me, my lord, but I have a case. It's not that it was my fault. But if you, but I am apprehensive of your lordship, my lord. If your lordship is not willing to hear me,
no. It's not that I will not.
But this is my suit for divorce.
Yes.
This is not the conduct, my lord.
Copy may be given, my lord. I have not
Let
filed
me
a
see.
No, there is no copy.
First hurdle, then I will direct.
There is
You
no.
have not lodged any caveat.
No, there is no.
All right, take your seat. Yes. Yes.
Suit for divorce, my lord, decreed in 2017, ex parte. My lord, I got married, my lord, remarried in 2018.
You are the husband.
Yes.
Why file a suit?
No. Suit for divorce, my lord, at my instance, it was decreed ex parte. Let me place.
Yes. Yes.
It was decreed ex parte in 2017. In 2018, I got remarried. In 2021, my lord, the order 9 was 13 filed after 4 years. That was proceeded initially ex parte because, my lord, the address was at Calcutta of my client. My lord, subsequently, my lord, came down to Padawan because his mother is staying there and she has gone over. My lord, then this ex parte proceeded because of this miscommunication. Summons were served, my lord, to the at Calcutta possibly, and he did not get it. Thereafter, he appeared, he filed a show cause, and my lord, he entered appearance and he filed all the legal statements and all. Then only on one occasion, he missed the date on 20th December, date was fixed for hearing. On that date, adjournment petition was filed on the ground that his mother was ill, he could not come. Adjournment petition is on record. The learned advocate, my lord, omitted to move it at the time of hearing. And on that very date itself, my lord, the evidence was taken, and my lord, it was fixed for argument.
Show me that order.
Lordship.
Show me the order by virtue of which the suit was, your prayer for adjournment was rejected and the suit was. Show me that order.
My lord, that is, my lord, my lord, that I am placing, my lord. This is the order. 2012.
You have not annexed that.
Certified copy.
You have not annexed that.
That is the subsequent order. 2012-2024. Kindly see, my lord. This is certified copy. And the adjournment petition I have, my lord, annexed in my application. Lord, I have no purpose to digress the matter. And well,
This is the miscellaneous case under Order 9 Rule 13.
Order 9 Rule 13.
Yes.
And the word
Order
kindly
9
comes to
Rule
my
13, you are the petitioner.
no. Suit was my lord, divorce was decreed, my lord, in my favor. It was my suit.
Yes.
Then my lord, Order 9 Rule 13 filed
Filed
by
by the
wife. And that, my lord, yes. And my kindly comes to page 37 of my application. This was turned, this was rejected. Page 37. Only in 1 day's fault, my lord. Mistake. And that also, my lord, after filing the adjournment petition. And it is, my lord, from the order sheet, it will transpire that the adjournment petition was there. But it was not moved by the learned advocate, my lord, for some reasons, my lord, he could not appear or whatever. And on that very date, my lord, the evidence was taken.
Why you did not file show cause?
My lord, show cause because I filed, sir.
You have been asked to file show cause on
Yes, in the earlier occasions, my lord, I have filed show cause.
2024. The next order records 26th of July. No show cause filed by the opposite party.
No,
26th of September 2024. It was another date was fixed for filing show cause by the opposite party.
Show cause reply I have filed.
Thereafter, yes, on 26th, after 2 occasions. On 2 occasions, it was adjourned. The learned advocate for the ex parte hearing is vacated. It was vacated.
Vacated. Yes.
Yes. So initially it was directed
ex parte.
You are asked to show cause. Then it was vacated.
And that show cause was given.
Yes. Then it was so. It's the first time on which it was vacated. Now,
yes. And this is the second time.
Yes. Petitioner files.
That reason, my lord, I have given, my lord. My address can list is the cost title.
Yes. Please wait. None appears for the opposite party. On 20th of December also, none appears for the opposite party.
No, 20th December is the adjournment. That is the only date, my lord, I made a fault.
Yes.
My lord, I filed, my learned advocate filed an adjournment petition, and that was, my lord, not moved. And that adjournment petition is page 37. My lord, kindly appreciate the earlier ex parte, my lord, proceeding was because, my lord, there was a dispute with the address. My lord, kindly please the cost title. My lord, there is no hide and seek. My lord, the cost title, my lord, the suit filed, I was residing at Calcutta. So that address remains. Now presently I am residing at Bardwan with my mother.
What is the next date fixed?
My date is 1st July.
Next date fixed is on 1st of July.
1st July.
So the petitioner's evidence has been completed. So on 7th of July, you lead evidence.
As your lordship directs, my lord, as your lordship directs.
My lord, only one thing, if he appears and contest, I have no issue, kindly, because he is.
I will direct on that date.
Yes.
He will appear with the witness to give evidence, and a date will be fixed.
For argument, no.
Yes.
Unnecessary, no.
That I cannot, my lord.
Please give him a copy.
Yes.
This application under article.
And no adjournment.
Pastor, on behalf of my learned senior Raju Bhattacharya. It is in Lexington courtroom number 1.
On the prayer of the learned advocate for the petitioner hearing of the
My lord, I am praying for make it not today. The advocate on record, Mr. Manav Malakar, is engaged in personal business for which I am praying for make it not today.
on the prayer of the learned advocate for the petitioner, the hearing
In this matter, madam, appearing for the petitioner.
Yes.
Now, the last order dated 21st of December 2024 is challenged. Last page, my lord, of the certified copy.
Yes.
On the failure of the learned advocate of the plaintiff petitioner, my lord, this order has been passed.
Suit has been dismissed. Order 9 rule 9. So,
but this is the position.
You have to apply under order 9 rule 9. What do you want?
Let that direction be given.
The learned advocate. Yes.
My lord, we are for the petitioner, my lord. Petition right of the petition. My lord, DP. I said, Father. Just shoot for partition. Please.
Yes, suit for partition,
Page number.
page number 44, plain. And
Thereafter injunction order.
schedule of the plain, page number 50.
Yes, yes. What is the impugned order?
Impugned order.
Impugned order.
What order you are challenging?
Order number 11, dated 7th.
What has been done by the impugned order?
Commission petition allowed. It is admitted fact.
What admitted fact?
There is a building of 3 storage. Their commission petition.
Where is the application for local inspection?
Page number হলো এটা
কত 70?
হ্যাঁ
Page number 70.
70 এই যে 70
পেজ নাম্বার 70 বাদী বিবাদীগণের বিরুদ্ধে
গ্রাউন্ডটা দেখুন
গ্রাউন্ড হচ্ছে এখানে বাদীপক্ষ সম্পূর্ণ অন্যায় ও বেআইনি মতে এবং অসামাজিক লোক লইয়া নানাছি দাগের ওপর এই বিবাদী পক্ষের বসবাসী জ্ঞাদি হইতে জোরপূর্বক বেদখল করিয়া দেবেন বলিয়া শাসানি সুচি ও ষড়যন্ত্র করিতেছে। এইটা হচ্ছে ওদের গ্রাউন্ড। এর জন্য কমিশন দরকার কি কি কাউন্টে লাগবে?
অলরেডি পুলিশ হেল্প অ্যালাউড
Already injunction was allowed and police help petition is allowed. Page number 64. They are well protected by the injunction order and the.
Where is the application for local inspection?
Page number 70.
Page number 70.
70.
70.
70.
They are 70.
তাদের নামটা লিখে ক্যাপিটাল ইজ ইট নাও
এখন অন্যায় আমরা ওদের থ্রেট করছি এবং ডিসপোজেস করার জন্য এই হচ্ছে উদ্দেশ্য। এই তো ফিশিং আউট অফ দ্য এভিডেন্স। Already injunction order was given and police help order was passed.
Running page 60 further.
The
Page 28 and for the petitioner, my lord. Suit for partition, local inspection under application under order 26 rule 9 was allowed before determining my shares, my lord. My lord, the application is at page 25. Initially, the application was filed on behalf of the defendant number 3, 4, 5, and 6. But they have, my lord, prayed for inspection only on defendant number 6, my lord, at page 26, schedule A.
This local inspection in connection with repairing.
Repairing, but my lord, before determining my share. My lord, kindly come at page 26. 25, my lord, they have prayed on behalf of defendant number 3, 4, 5, and 6. My lord, kindly come at page 26. All that accommodation exclusively possessed by defendant number 6, measuring about 7 decimal. That is the, my lord, entire bastuland in the suit, partition suit, my lord.
Repairing, let it be done. Whether if it is necessary or not, that will be considered thereafter.
My lord, they are trying to, my lord, repair the whole entire structure, my lord.
Repairing application has not been allowed.
No.
So it's a local inspection. Let the picture come before the court.
This matter, I am appearing for the opposite party number 1 to 4, my lord. I am led by Mr. Samal Kumar Chakraborty, my lord.
You are led by Mr.
Samal Kumar Chakraborty, my lord.
Yes.
My lord, if he could not come today, my lord, over phone he told me that he would come, but He is ill, my lord, kindly take up the matter day after tomorrow.
Unfortunately, my lord, my difficulty, I will not be here day after tomorrow, my lord. And there is some urgency in the matter. I do not oppose at all. But here, my lord, your lordship, on the face of it,
What is the order impugned?
injunction granted to a human being or a trustee who has no right on the property. And it is admitted.
How can it be an appellable order, Mr. Chatterjee?
Appellate court granted.
Appellate court's order.
Trial court grants it, appeal court dismisses the suit. Dismisses, my lord, the appeal. Kindly have a look at
Dismisses the miscellaneous appeal.
Yes.
So it's not only the ad interim prayer refusal in the miscellaneous appeal.
In the miscellaneous appeal.
No, no, no.
No, appeal was dismissed.
Appeal was dismissed.
Appeal was dismissed. My lord, kindly turns to the impugned order once.
So the initial order was an ad interim order of injunction. So I'm directing the injunction application.
For a second, my lord, the injunction can't stand. I'll show your lordship that.
Injunction cannot stand.
Cannot stand. Kindly have a look at page, the impugned order once.
But this was from July 2024.
My lord, if he had even a semblance of a right on the property, I would have understood. This is not a public
Strategy,
interest
your friend
litigation.
is in difficulty for this.
Sir,
That
I
is
am in real difficulty, my lord. If I was not, I would not have told your lordship. I am the last person on earth to, my lord, oppose a prayer for, my lord.
Yes, where is Mr. Chakravarti?
But he told me over telephone that he is coming on the way. But
Then
He's
keep it at
coming.
2 o'clock.
suffering for
2 o'clock.
few days, my lord.
So I'm keeping it 2 o'clock.
No, my lord. Thereafter, my lord, I rang several times, my lord, but could not.
I'll show your lordship just one.
Only day after tomorrow, my lord. kindly.
Not,
He will not be available.
I am not here.
Tomorrow,
Bro, weekটাতে আমি নেই। আমি কালকে দিল্লি চলে যাব।
Mr. Chatterjee will not be there tomorrow.
I will not be there, my lord. If that was, I'm the last person on earth. If my learned senior friend can join online also, my lord, because I will not take more than 5 minutes and show his plaint only, nothing beyond that.
Yes, ask Mr. Chakravarti to, if not possible, to come at physically by virtually. 2 p.m.
Or let us try at 2, my lord.
But I cannot.
A problem and I have to leave as well. So it's-
Today?
Yes, my lord, I have developed an infection in the leg. I cannot stand for long.
Mr. Chatterjee, if that is so,
no.
Mr. Chatterjee, you can make your submissions by sitting.
No, I'm here, my lord. I will finish it and go. Because this is on a property, my lord. I'll tell you, lordship, in a nutshell what the problem is. The problem is, this is a trust who is the plaintiff, who has got no right over any part of the property. They are trying to espouse the cause of a school over which, my lord, the school has never paid for any injunction. The injunction is granted as if the school is paying for an injunction.
But the school is run by the trust.
No, it is not. That is the main problem. It is not run by the trust. They have made a trust of their own, saying there are rickshaws and things like that.
Show me the
plaint.
Show me the order of injunction,
my lord,
which was passed.
Looks to the appellate court once first, thereafter your lordship. See page 6 of the appellate.
Which is the most comprehensive one?
Page 6.
The appellate court's order.
My lord.
Page 6.
6.
No,
sees the third
it's the
paragraph.
appellate court's.
It is also found that in the impugned order, the learned trial court has made the
It is
following
also found in the impugned order. Yes.
has made the following observation. Now, kindly looks to this. On perusal of the documents
So this is the trial court's order, quoted.
Quoted. On perusal of the documents produced and considering the submissions made by the learned advocate, it prima facie appears that the plaintiff school has been recorded permissive possessor. Plaintiff school, kindly marks that. Plaintiff school. Then,
so according to you,
plaintiff is not the school. No.
Yes.
As well as LRROR of Khoitan number, Khotian number.
RS and LRROR, whose name has been recorded?
School. School, that too, permissive occupier.
Yes.
And
Under
also,
you.
yeah, I am the one, Milan, I am the owner of the adjacent property. They are saying, my lord, that this property is used by the bikes and rickshaws and things like that. That is why there will be a problem with respect to the entry and ingress of the school. That is why an injunction should be granted.
Easementary right.
Not even claiming that. Not claiming that. But the statement there is that they could have, even the school could have claimed that easementary right. They have not.
Yes.
There exists a strong prima facie case in favor of the plaintiff.
No, and there also exists a trust deed
That is there.
in respect of the plaintiff school.
That's exactly what I'm trying to say. 4 people have formed a trust and they say that it is in respect of the school. No, separate entity altogether. And I'll show that from the plaint itself.
Yes.
Money, hence, considering the aforesaid fact urgency. In this background, it is categorically argued on behalf of the principal respondents that the trial court has discussed. My lord, your lordship comes down. Need not trouble my lord self. Accordingly, the entire above discussion and observation lead to the inescapable conclusion that in the misappeal, nothing has been shown or established on behalf of the appellants to hold the impugned order suffers from irregularity. Finished. Over, done with. Kindly turns to the plaint ones. Have a look at it, the cost title at page 19.
But Mr. Chatterjee, only one thing, this order of injunction ad interim is continuing for long.
Yes.
So,
Lord, I say for a second it should not.
So I can fix this immediately after the vacations.
Lord, the injunction will go on forever.
No, not forever. So it requires some hearing.
There is
because
no
this order was
of a hearing.
Yes, but Mr. Chatterjee.
Lord, if I would say that if it required long drawn hearing, I would have understood. Because the injunction is granted on the ground that the school has preferred the suit.
I appreciate that.
Nothing.
I appreciate that, Mr. Chatterjee. I'm posting it just immediately
outside.
Immediately after the vacation, when you will be available.
Gives me 1 second. On the reopening day, let it be on the first day.
I'm posting it in the second day.
10th.
10th or 11th.
As motion, Miller, at the top, kindly, Miller, because first day would be the monthly list.
That is why I'm saying not the first day. Second I'm posting it on 12th.
My lord, I am appearing for the petitioner, my lord.
Yes.
My lord,
You are appearing. You have been served. Yes.
The order impugned, my lord, dated 24th March 2025. Operating portion is that the petition dated such and such filed by the appellant is allowed on contest without cost on condition that the appellant will deposit in the court or will pay to the respondent 53,580, which is area of 42 to 47 monthly installments of the auto rickshaw as mentioned in the award by 27th March 2025, and also file deposit court fees of rupees 1,000 before this court. My lord, my humble submission in this regard, this is the proceeding under section 34 of the Arbitration Conciliation Act 1996. Under the court, first point is this, under the Court Fees Act, as provided in the Schedule 2, when the value of the award exceed of rupees 50,000, then the court fees will be the 5,000 rupees. Instead of that, the learned court below has directed to deposit 1,000 court fees. If your lordship.
So Bhattacharya, that is a dispute between the court and the state. Can that be a ground for challenging an order? I will direct him to deposit the balance amount 4,000. 5,000?
No.
According to 5,000, 5,000, you will deposit that.
Deposited 1,000, we will deposit 4,000.
So I'm recording the submission that will deposit the balance.
Another issue is, my lord, that it has been also directed to pay the area of installments.
Yes.
But my lord, the award is containing with the interest, and any interim order passed in this regard, it is tantamounts to, my lord, it is a stay. So otherwise, if we issue the NOC in regard to the hypothecated vehicle, we have no control over the said vehicle.
No, according to you, interest, where is the arbitration award?
Arbitration award, my lord, in the page 33. Start from page 33.
Mr. Rai, does it provide for interest also?
The total award is 2,43,445. My lord, if your lordship.
40?
2,43,000.
Page.
Page 33, my lord.
Yes, together with 18% per annum. So how much does it come?
2,43,445, which has been awarded.
No, but they have preferred an appeal. They have paid for setting aside of this.
Setting
So
aside
if the entire amount is paid, nothing remains in the appeal.
I am not on the issue. If such types of interim order would be passed, my lord, my humble submission
But
is.
Mr. Rai, only one thing. If they are issuing this no objection certificate, nothing remains.
No, that vehicle is 15 years old. It cannot ply on the road. I have to purchase a new vehicle. Lordship will kindly appreciate.
But the only thing is that how they can recover the balance amount.
From the vehicle, they cannot. We have
From you also.
Yes, we have already paid much more than that. We have already paid 4,25,000.
No, Mr. Rai, please come to page 33.
Yes.
So page 33, there was an order directing you to pay 2,43,445.
Yes, that is the subject matter of challenge. We have stated in our application that we have already paid 4,25,560.
Yes.
Now, this vehicle is 15 years old. It cannot ply on the road.
Alright, so then I am directing the appeal to be disposed of in the meantime, but no, this no objection certificate cannot be issued for the present.
If I do not get this no objection certificate, then I cannot apply for a new vehicle.
You have to wait for the hearing of the appeal. I can 18th of June has been fixed for hearing of the appeal. I am directing the hearing of the appeal
On
to
that
be
day
expedited.
My lord, in this regard, I am referring the section 36, subsection 3. Upon filing an application under section subsection 2 for stay of operation of the arbitral award, the court may, subject to such condition as it may deem fit, grant stay of the operation of such award for reason to be recorded in writing, provided that the court shall, while considering the application for grant of stay in the case of the arbitral award for payment of money, have due regard to the provision of grant of stay of monetary degree under the provision of the Code of Civil Procedure. So if they secured the amount by depositing in the court, I am not submitting that they will pay the entire amount to us. If they deposit to the
No, we have already deposited this amount, 58,000, we have already deposited.
entire awarded amount.
The 58. He says 2,43,445.
Yes.
That is the award.
That is the award. And
Mr. Rai, what is the principle of stay in a money decree? This is a money decree. So if you have
they
to
have
obtain.
not filed any execution. They have not filed any execution.
No, but the arbitration section 34 says that.
36(3), my lord.
Yes. Please come to that. So you are not praying for stay of the arbitral award.
Here I am not praying anything, Lordship. We have only prayed that let me obtain that.
So that can also be directed.
Directing issuing of NOC, my lord, it is
We have not
tantamount
filed
to
any stay
stay,
application.
stay of the award.
Lordship, we have not filed any stay application. Lordship will not direct anything. Let the appeal be heard out.
But this has to be stayed. They cannot also be directed to issue the no
No,
objection.
no, if your lordship is directing the appeal to be heard out, then I do not need that no objection right now, because they are not issuing the no objection.
Where is your application dated 21st of March 2025?
Yes, lordship. Yes, that is at page 34.
Uh, It is also recorded that the please take back this certificate. Go to the second.
Lordship, item 31, may I move it virtually, Lordship?
This is
Lordship, this is an application challenging the impugned order, Lordship, which is at page 53, whereby the commercial court sitting in the limit below court, the commercial court has allowed a written statement to be filed after 120 days, Your Lordship. It is, Lordship, I am relying upon the Order 8 of Commercial Courts Act, which is held, says it is mandatory. And Lordship, I will also rely upon the judgment by the Honorable Supreme Court and judgment by this Honorable Court, whereby it has been upheld that 120 days is mandatory, Your Lordship. Lordship, at page 53 is the impugned order, Your Lordship.
what is the delay when it was filed?
Lordship, it was filed on 14th of June 2024 on the day it was accepted, Lordship, as it says in the impugned order. Defendant number 1, Mighty Traders, file written statement. Copy not served. WS filed by defendant number 1 is accepted, Your Lordship.
Advocate, petitioner submits that sixth bench. It says learned judge sixth bench.
Lordship, 6th bench City Civil Court sitting in commercial division, Your Lordship.
Learned judge, sixth bench. Places reliance upon the decisions.
Lordship, decision is SCG contract 2019-12 SCC 210, Your Lordship. Paras 8.
Places reliance upon the decision of the Honorable Supreme Court.
Lordship, I am also relying upon this Honorable Court's division bench judgment, Lordship, in Raijada Marble.
That the you have not paid for stay.
Lordship, I have prayed for Lordship. This is my proceeding. I have not prayed for stay of this. I have seeking set aside.
It has to be set aside. Cannot be without hearing the other side. So it has to be stayed. There shall be an order of stay of all further.
Deeply appreciated.
My lord, in this matter, I am appearing on behalf of petitioner, my lord. I have challenged, my lord, order 29 dated 6 February 2025, London Second Civil Judge, Senior Division, Contai Court, past and maintenance order, my lord.
Where is,
My lord,
what is the order dated you are challenging?
yes, my lord, order dated 6 February 2025. Second,
6th February 2025.
huh,
Where is
second,
that?
my lord, I have annexed certified copy.
You have annexed
Maybe-
many certified copies. It's difficult
Yes,
to
my
find
lord,
out.
it's maybe 15 or 16 page of certified copy. My lord, may I?
Why are we annexing certified copies of all the pleadings?
Yes, my lord, it's very much necessary in this case.
Why are you annexing certified copy? You can annex the photocopies. Why are you wasting this?
And all these photocopies. Oh, but
No, this is the certified copy. Please see the original
yes, my lord,
pleadings.
also with the planes and all the applications.
You can annex, madam, this photocopies. It's not necessary to annex. Sheer wastage of money.
But my lord, only
The 6th of February 2025, yes.
yes, my lord. My lord, my lord, second civil judge senior division passed an order of maintenance, my lord.
Yes.
Yes, my lord.
Who are you?
I am husband, my lord.
Yes.
Yes, my lord.
Pay maintenance.
No, my lord. My lord, kindly give a look one thing, my lord. Maintenance the word. Which judge can use this word maintenance? My lord, if one person can claim maintenance or entire monetary relief, my lord, first they can come for 125 or domestic violence or 24 of Hindu Marriage Act, 25 or 18 Hindu Adoption and Maintenance Act, my lord. Under section 18 Hindu and Adoption and Maintenance Act, who can be adjudicated, my lord. There is only one civil judge, my lord, that is family court. Family court is the only one civil judge who can adjudicate it on 125 as well as domestic violence as well as under section 18 as well as 24, 25, all of them. Otherwise, my lord, second civil judge senior division as a sub judge on sitting of his chair, my lord, cannot adjudicate that matter. Second point is, my lord, why I am attached all the certified copy of this order, my lord. My lord, next page of certified copy, it's started with plain under order 7 of rule 1 CPC. My lord, next page, page number 2, for maintenance and consequential relief of declaration.
Where is the application for maintenance?
My lord, that is the application for maintenance.
No, this is the order. Where is the application for maintenance? Which page?
Just next page, my lord. Annexure P1 also and next page of a certified copy also. May I, my lord? My lord, annexure P1 also.
Yes.
My lord, that is a suit filed for maintenance and consequential relief of declaration of charge. 19,000 maybe they
Only 5,000, madam, has been directed to be paid.
that is not a dispute, my lord. Maybe 5,000, 50,000.
So in the meantime, you pay, I will decide that. Please pay.
If I started pay, my lord, that means that is adjudicated.
I will make it clear without prejudice, please pay. Asun, this application under Art.
Give me one chance. Maintenance and consequential relief is cut. File the same
All right.
suit, my lord.
I will hear you. Please pay without prejudice. This application under Article
matters 39.
Lord, the plaintiff, my lord, is the petitioner before your lordship.
We are appearing for the defendants in this matter, your lordship. We haven't been served with a copy of this revision petition, but this is,
They are not entitled.
but we are appearing today, this matter is listed. And therefore we undertake to file our wakalatnama also.
They were entitled to file caveat if they were so conscious about, my lord.
We are being led by Mr. Suman Kumar Datto. He is appearing online, your lordship.
Sir Kormakar, why don't you give a copy to them?
I don't have any problem. Lord, they could have asked, but they knew it. Today the matter is fixed. Lord,
I did not know, your lordship. We came to know only on the last occasion when the matter was.
Very well, my lord, if Mr. Kormakar is entitled to say that we have not lodged a caveat, but once I have appeared, he is not entitled to say that I don't give him a copy.
Give him a copy.
And Milal, I must tell your lordship, Milord, my clients have also preferred a civil revision against the same order, which is
also tell where is that?
Milord, that Milord, I believe Milord, since my clients are in Bombay, I'll receive it in the course of the day. I'll file it tomorrow so that
it is when it will be appearing.
Milord, we have not yet filed it. It's been affirmed and it's coming from Bombay, Milord, so it will be filed probably tomorrow. And therefore, Milord, it can appear both these can appear day after tomorrow. Or Milord, your lordship does this, Milord, let my landed friend's application appear day after tomorrow. If I file it, Milord, then in that event, Milord, your lordship can take it up by consent of the parties.
What I understand is, Milord, if revision has been filed, Milord, then advance copy can be served upon us.
That can be done.
It will be filed tomorrow. Tomorrow.
Then, Milord, the problem
Of course,
is
Milord,
my money. The problem is my money. The court has come to a finding in a Order 37 suit, come to a finding that there is admitted
Mr.
dues.
Kormakar, if the other side is also challenging, so both has to be heard together.
Lord, they have not yet challenged. We had challenged this last week. After mentioning this matter, it has been fixed today for hearing, Lord.
Our problem is, your lordship, that the client is.
No, I understand, Lord. Mr. Dotto is appearing, Lord. I will not, Lord, but I have also, Lord, to be accountable to my client. Lord, last week I had filed. They were following the matters. They were informed that we had preferred revisional application. They did not file, Lord, caveat. Instead, they are now contemplating to, Lord, challenge the order.
Mr. Doctor, one thing, unless you give a specific date when it will appear, it's difficult for me to keep this matter on that particular date.
I appreciate that, Milord. My advocate on record, Mr. Dotto, is there.
There is nothing from your end. No application also you are.
Yes, I appreciate that. I appreciate that, Milord. So in that event, Milord, let's take.
That is
Very well, Milord. In that event, Milord, what I am suggesting, subject to what falls from my lord, let him serve a copy of his application. In the meantime, if I can get my application filed and listed.
Everything on your application, I am directing Mr. Kormakar to serve. Please
The
serve.
difficulty is today, your lordship does not take up this matter. This matter will again, because of the CIF system, Lord, it will go again, Lord. It will never come.
Let me see what
your lordship is knows better than me.
When this Wednesday, I have directed under the same heading I have said.
Lord, in that case, if the matter is not taken up, I'll have a liberty.
Yes. I'm deeply obliged, Milord.
Mr. Kormakar, it could have been reached today because I have completed up to 32.
Yes, Lord,
Really, it could have also reached.
But Lord, at some time, because of some matters, Lord, it happened.
Your lordship, may it be please appear on Thursday, not on Wednesday.
No.
Lordship.
Lord, I appear
Yes.
for petition, my lord.
Yes.
Lord, I have filed my wakalatnama in the department. Will let a copy be served upon me.
My lord, will your lordship give me 2 minutes just to explain what is the urgency, my lord? I can give him a copy. I don't, my lord, shy away from that. My lord, this was really for expeditious disposal of an application. This sufferance today is by reason of an order.
Disposal of
No, the sufferance, I don't have a forum, my lord. The quorum is not there, so I cannot move my application there. My application before the state commission, my lord. Now the
quorum is not
no, there is, my lord, it requires, my lord, two, my lord, members. One of them is there, the other is not there. So, my lord, orders are being passed, only adjourning the matter. My lord, the difficulty is by reason of an order of thirds.
quorum is not
That is
there.
why I am before your lordship, and I want to convince your lordship what has happened is in an execution proceeding, an application was filed challenging, my lord, disconnection of a notice issued by DVC for, my lord, arrear tariff. This had got nothing to do with the parent proceeding, which was, my lord, the complaint case.
There is a proceeding pending, appeal pending before the Honorable Division Bench on
That
this
is my,
issue.
yes, there is, but there are number of consumers. This,
Yes, but
this
the
person,
issue, same issue is pending before the Honorable Division Bench. I think this has to be heard along with.
no, my lord, that is not a, my lord, that will not be a problem. Why I say this? My lord, the division bench, in fact, I am protected by the division bench order also. All consumers have been directed to pay 50% cash, 50%
That is
BG.
why it will be better if this matter is directed to be heard by the Division Bench.
My lord, division bench will not, my lord, have otherwise the jurisdiction to hear a civil revision application. Today, my urgency is this, my lord, because of the order of 3rd September, this particular consumer is merrily enjoying supply of electricity, and despite there being arrears of tariff, I am not in a position to take any steps because the executing court has passed a blanket order saying that you will not disconnect. My lord, can this be, my lord, sustained? My lord, is the only question to be considered today, my lord.
There are very many issues. I think maintainability forum, which
My
forum has
application for maintainability is pending.
appeal also. There is a forum of appeal.
My lord,
Very many
on one
issues
issue,
are
lordship will be with me.
because I was there in this type of
My lord,
matters
on
while
one issue, lordship will definitely be with me.
yes, the
That I
Division Bench
cannot
order
have.
has also been annexed.
I have, my lord, I have, my lord, only one issue I want to, my lord, cite or I want to indicate that there is lack of quorum in the state commission. Therefore, I cannot, my lord, move the application. That is, my lord, a fact.
This is today's cause list, my lord.
Only one thing.
Both the members are there.
Only one thing. The issue, civil revision application also can be heard by the Honorable Division Bench. Because if interconnected issues are pending before the Honorable Division
Then
Bench,
lordship has to observe that and then release it, my lord. I can get it assigned. But my lord, the difficulty still will be, my lord.
some of the issues are pending before the Honorable Division Bench.
My lord, according to me, my lord, this issue had got nothing to do with, my lord, the division bench issue because they have not challenged the orders.
You are also appearing in the Division Bench matter. Some of the
They are all
the issues
interlinked.
are same.
They are all interlinked. Because, Lord, it all, Lord, started with a direction on the DVC to, Lord, refund a sum of rupees 50 lakhs, which culminated, Lord, in the subsequent proceedings. They challenged it before the State Commission. Then State Commission passed an ex parte order. We came to 227 in 227. That proceedings was stayed. And thereafter, Lord, this disconnection notice, that is again, Lord, the subject matter here.
They challenge unsuccessfully before the High Court.
The only thing I was only thinking, because since I was part of that Division Bench, some issues which Mr. Datta is saying, it appears that it's interconnected.
My lord, I can show, my lord, lordship gives me 2 minutes. I will show it not connected.
With the Division Bench.
Lord, at least, Lord, let us have a copy of the petition.
No, of course, I will give a copy. Of course, my lord, I will not shy away from that. But I wanted to convince your lordship that the issue is no way connected with the division.
Can it be taken up after the vacations?
My lord, I am
the urgency that
the urgency. My lord, I will tell your lordship. The real urgency. I am representing, my lord, DVC. My lord, what is happening is all consumers who have, my lord, crores of outstanding, my lord, one day or the other we see, my lord, IBC proceedings initiated. And my lord, because of the law in the, my lord, in some consumers are we are not in a position to recover, my lord. Today, my lord, this is public money. We are not in a position to recover.
You serve and
every day means, my lord, loss to revenue.
I appreciate that. I am posting it after the vacation, or if both of you agree, I can direct this matter to be tagged along with.
No, if lordship is not willing.
After the vacation, let them supply us with a copy. Lord, there is a money decree in our favor, which is greater than their demand, much greater than their demand. So therefore, kindly fix it after the vacation. We'll come back to your lordship.
My lord, then let that be the understanding that lordship would hear the matter. Then, my lord, after vacation, I don't want Mr. Court to again indicate that issues are interlinked. You should go to the my lord. Either I go today or I come back to your lordship. I have no problem with either of it.
Advantage of my learned.
Today they are not having a copy.
Yes,
That
advantage
is the
of my
difficulty.
learned friend is that
Mr.
he's having
Kaur
a copy,
may
I don't have a
have
copy.
to be given an opportunity to go through your application.
My lord, give
Whether
me,
these
my
issues
lord,
are
give me
interlinked.
2 minutes. Mr. Kaur will understand why am I saying that the issue is not interlinked. Give
Mr.
me 2 minutes.
Mr. Dotto, Mr. Kaur may understand that, but he has to take instructions from his client. He's a creature of instructions.
One more day, may I come back before vacation? I will give him a copy. Thursday, lordship keeps it. Please give me one opportunity.
Please see, because I think this matter, even if I take up, it cannot be disposed of before the
My lord,
vacation.
today I would be, my lord,
Other small matters.
my lord, I
maybe if
would
it
be
is-
seeking a stay of the order of the executing court, which is absolutely or wholly without jurisdiction.
When that order was passed.
3rd of September, I have been, my lord, moving my lord from pillar to post to have my application heard.
I give him a copy. I'm posting it just after the vacation. Ashun, when this
Precedence, my lord.
listed motion, what more precedence, Mr. Dotto?
Lordship understands the predicament this side. Lordship has been here. Lordship knows what difficulty we are, my lord. We also understand your lordship, my lord,
consider
the
this.
burden lordship has with this kind of determination. Very well.
It's
my
the
lord,
only difficulty. Otherwise, I could have fixed another day prior to the vacation, but it's only that.
I was only hoping for that. I could have served
I've
today and I could
posted
have
it
come.
under the heading motion immediately after the vacation. Yes, call the next matter.
Appear on behalf of the petitioner, Milord. I am being led by Mr. Roy, Milord. He is at the circuit bench at Jalpaiguri.
You are led by Mr.
Roy, Milord. Milord, he is at the circuit bench at Jalpaiguri. Kindly, Milord, takes it up tomorrow, Milord. I am praying for an accommodation.
Tomorrow it will be usual thing.
Milord. The trial court, Milord, rejected the injunction, Milord. I am the defendant, and Milord, in the appeal, Milord, it was reversed. Trial court hold Milord prima facie, Milord, the plaintiff.
So the appellate court has passed an order of injunction.
Yes, Milord.
It cannot be
Milord.
stayed. I am directing you to serve.
Yes, Milord. But in the meantime, Milord, what they are doing, Milord, taking advantage of this order, Milord, they are doing, preventing us from doing any kind of.
Is it ad interim or temporary injunction?
Contested.
Contested.
Contested injunction, Milord. Now what they are doing, Milord, they are not only restraining me, they are, Milord, restraining the other co-sharers, and Milord, they are restraining the other co-sharers from doing any kind of pisciculture activity over the property, Milord. The suit property involved are all, Milord, water body.
Where is the order of the appellate court?
Appellate court, Milord, last page, Milord. Certified copy.
By the order impugned. Next matter.
My lord, I appear, my lord, on
I am
behalf
led
of the
by
petitioner
English
in this
medium,
matter.
Bengali medium.
And I'm led
I
by
have been
Mr.
said, my lord, that 21st of this month, my lord, has been fixed by them for talking about this thing, my lord. 21st of this month.
But we have given a letter, my lord, indicating the 5 SQs pursuant to my lord's order on 28th of April.
Mukherjee, you
We
are
have not-
for whom?
I am led by Mr.
You are
My lord, I am appearing for the petition. I am sorry, my lord, I should have introduced.
My lord, we have given them 5 options. At least let them choose.
This is exactly why, my lord,
Mr. Rai, what is the difficulty?
my lord, 21st is the date fixed for by them. The learned advocate on records of both the parties have fixed 21st.
Of May.
Of this month, yes.
May.
Day after
For
tomorrow.
what?
For this, for coming into conclusion in this, my lord.
For what?
I have
What conclusion? Mr. Mukherjee says through his advocate on record that they have given suggestions of 4-5 schools.
5 schools.
That is what Mr.
5 SQs, my lord, we have given. Of the first one is Narayana, which is a very reputed SQ.
That, my lord, because Lordship kindly recollects, on the earlier occasion this matter was taken up, this honorable court was pleased to, my lord, direct us so that the parties, my lord, also sit together. So, my lord, after there was an examination going, and after this, my lord, date has been fixed on 21st, when, my lord, they are supposed to sit together and talk in this. So, my lord, I do not
But
know.
we have given the letter on 7th of May. We have given the letter on, because, see, the urgency is because of the session started.
This in the sitting also they will give their suggestions on these 5 schools.
Yes.
Why not to take any instructions on these 5 schools? And
Today is the
that will be
visitation
very-
from going on from 2:30.
So, very well.
visitation is going on.
Very
Yes.
All right. So do one thing.
I do not, my lord, one thing I just do not fail to understand. But while, my lord, the learned advocate on records were talking between themselves, then why did they agree on 21st? If they come and
Mr. Rai,
this
Mr.
matter
Rai,
before this
don't
honorable-
complicate these issues.
Absolutely,
So
my
if
lord.
today is the date for visitation, both father and mother will be there.
Yes.
So they can talk together on that.
Yes, my lord.
Are they on speaking terms?
Yes, they are. At least they're on the visit.
Yes, Mr. Mukherjee. What is your
My lord, I tell you, lordship, lord.
speaking terms?
Blood, there is a blood. The relationship is estranged. Blood, no doubt about it.
No, are
So,
they
blood,
speaking terms so far as the child is concerned, or they are not on speaking terms?
but when the father proposes, blood, admission to a good school, and mother says, "No, I will not be cooperating," your lordship can well understand, blood, the level of cooperation that I am supposed to.
Mr. Rai, do one
So
thing.
they, my lord, do not want to talk.
Mr. Rai, do one thing. This they have suggested these 5 schools.
My lord.
You take instructions from your client. I'm fixing this matter tomorrow.
I
Please
shall-
take it. That is the end of the matter.
I shall-
Whether she is willing or not willing, then I have to pass an order.
As your lordship please.
So these are the 5 schools. They have given the distance also. The traveling time is nothing because it depends upon the
Even in Calcutta, my lord, it is more than this.
traveling time is nothing. So
Very well.
the distance is has been mentioned, and all these are English medium schools.
Yes.
Suggested any Bengali medium school,
No, no,
Mr. Mukherjee?
Bengali, they cannot.
Because this child is studying in a Bengali medium school. Mr. Mukherjee is thinking only one thing. It's not that all Bengali medium schools are not, none of the Bengali medium schools are good. It cannot say that. Even there are good Bengali medium schools also. The child is at present studying in a Bengali medium school. Putting him from Bengali medium to English medium may at times create some problems for the child. If after all, the welfare of the child which is to be taken into consideration.
Lordship.
I want to suggest some good Bengali medium schools also.
But I'll ask my client whether not there are good reputed Bengali medium schools are there or not. If not are there, then I'll ask my client to suggest names.
Because if the because the
I'm given to
in which
understand-
class
I'm given to understand there is a Ramakrishna mission also.
Bengali medium.
Bengali medium. But
So why you have not suggested that?
my lord, the medium of teaching in Ramakrishna mission is probably English, but it is Madhyamik. West Bengal board.
Some Ramakrishna mission schools have both mediums.
We have to take.
I have personal knowledge on
My lord,
that.
let my learned friend consider these 4, and we are also
And
these 5.
during our times, the results of the performance of the Bengali medium was much better than the English medium in Ramakrishna mission. that
And
much.
we have very good lawyers, Lord, in High Court who have, Lord, passed from Bengali medium schools.
Yes. That is why, and Mr. Mukherjee, that is why I was saying that you cannot say that there is no good Bengali medium schools, only English medium schools or the schools of ICSE and CBSE are good, not that of Madhyamik board.
No, no, definitely.
That much I cannot accept that contention of yours. So the mother says Bengali medium, the child is presently studying in a Bengali medium school. Why don't you?
Yes, Lord.
Any reputed Bengali medium school?
In course of today, we shall name.
Ramakrishna Mission is residential or?
We shall take detailed instruction, and in course of the day, we'll inform the advocate and record of Mr. Rai. In course of day, in course of today.
Then tomorrow cannot be done. I'm keeping it then day after.
It was fixed by them on 21st. I don't
They had suggested.
I mentioned before your lordship.
All right, I'm keeping on 21st.
The difficulty is, Lord, about the courses having started.
Tomorrow also. I don't mind, man.
No, I'm keeping on 21st. So
can we keep to tomorrow also, because the dates are given by them, my lord. So if it is tomorrow, I don't mind.
Suggested my advocate and record agree.
Then why are you taking that? They have given a date. It cannot be before that date. They have given us suggestions. Why are you complicating this?
I'm not subject to
lordship
is perhaps I know I'm not being able to make myself clear, because I am trying to, my lord, assist the my clients and the advocate on record, my lord. They, after, my lord, talking with them, they themselves, my lord, fixed 21st. When this morning I called up and I said that today's matter is fixed at 2 p.m. Then they said that the learned advocates on record, both of them have mutually decided it will be taken up on 21st. Why it is at 2
Mr. Dotto, did you give notice to them before mentioning this matter?
Yes. Gave more notice, my lord. Definitely, my lord. They have given notice, my lord, but as I said, my lord, they themselves decided 21st, but
it was a proposal from.
All right, I am keeping on 21st.
Your lordship, please, my lord.
As you have said that it's fixed on 21st, I am keeping it on 21st.
Because I am being questioned by them, but since I said that 21st is the date, so it is already agreed. Now I this morning called up and said that it is at
Mr. Mukherjee, learned senior advocate for the petition. Any other Bengali medium? Mr. Dotto, give it to them. Full stop. Solution, I think it's any school, English medium. If the child is studying in a school, the suggestion is to a better school. Why don't you accept? And the father, Mr. Mukherjee, you have expenses.
Yes, my lord, we have agreed.
And you have to assure the court that you will take all steps for getting the son admitted therein.
Yes.
Yes, Lord. So far as these 5 SQs are concerned, Lord, we have taken already steps, and we say that all the expenses will be borne by the father.
Including
not only the expenses, the admission, there is a procedure, whether they will be admitted or not. So you have to take all the steps.
But so far as the 5 SQs are concerned, my client had a talk with them, and thereafter, Lord, has proposed.
So please take instructions on some Bengali medium schools as well.
I'll certainly do that, Lord. I'm grateful to your lordship.
Yes. Grateful. Call the next matter.
Grateful, your lordship.
This matter 33.
Yes.
Defendant number 2, petitioner before your lordship, my lord. Suit for partition and permanent injunction, my lord. My lord, the preliminary decree was passed. Thereafter, my lord, the partition commissioner was appointed, and my lord, the commissioner only went one day for the commission work in the, my lord, suit premises, my lord. Thereafter, my lord, the several dates were fixed for the, my lord, report of the partition commissioner, my lord. And suddenly, my lord, by put up, my lord, the record was placed before a charge court without any notice, my lord, without any notice, my lord. That has been, my lord, filed, my lord, behind back of the, my lord, defendant number 2, my lord. So no scope given, my lord, to the, my lord, petitioner, defendant number 2, my lord, to file any objection against the, my lord, report. My lord, my client filed an application to
What
record
happened?
that order, my lord.
What happened thereafter?
My lord, my
What
client
is the
filed an
order you are
application.
challenging?
My lord,
Which order you are
my
challenging?
lord, order number 95, my lord.
Order number 95.
My lord, dated 5th March 2025, my lord. My lord, bunch of, my lord, certified copy, my lord, I have, because I cannot
There are many
segregate it, my
bunches of certified copy.
my lord.
Preliminary decree
95, my
also.
my lord, before that, my lord, my
5th
petition,
March. What is the order dated 5th of March?
5th March 2025, my lord. My lord, before that, my lord, kindly, my lord, look into my petition, page 80, my lord.
Give me a minute.
My lord. My petition not dealt with, my lord.
Final degree has been drawn up.
My lord, my
You
lord,
have to challenge the final degree.
but my lord, I have not given any scope, my lord, to
You
challenge.
can take that point in the final degree. Where is the final degree? It has been drawn up, it has been said.
My lord, for a moment, my lord, page 80, my lord. Kindly see, my lord, page 80, my lord. My lord, the cause list showing another, my lord. My lord, the page 79, kindly see, my lord. Every day, my lord, my client take these steps, my lord.
I
My lord,
follow that. Now, since the final degree has been passed,
my lord.
how a 227 application is maintainable? Final degree, you cannot challenge a degree in a 227 application.
I have challenged, my lord, this application, my lord, for
Sir,
recalling that order, my
yes, that has been rejected on the ground. The final degree has been drawn up.
my lord.
Where is the scope for considering that? Where is the final degree?
That has not been, my lord, annexed, my lord.
Final degree has been drawn up. You have to challenge the final degree. So I'm giving you the liberty to challenge the final degree in accordance with law.
My lord.
petitioner is permitted to take that.
Yeah, please, Your Lordship. My Lord, by the two impugned notices, my Lord, the Ranaghat municipality has directed to demolish the structure. My Lord, Your Lordship kindly, without my Lord inviting me in a demolition process, or
Without inviting
me in that participate in the demolition, my Lord, process, and my Lord also serving the copy of the order.
Who are you?
I am the evident of the, I am the owner of that property.
You have made illegal construction.
No, no, no. Your Lordship kindly sees, my Lord. I
You have
filed
not
the
made an illegal
No,
construction.
not at all, my Lord. A clean structure. Your Lordship kindly sees, I challenge the order, the notice rather. I have never been served with the order itself. I challenge the notices, two notices in an appeal, municipal appeal, my Lord. The learned trial judge, my Lord, rejected my application for injunction. The impugned order.
Where is the order of demolition?
Demolition order has never been my Lord, supplied. I prayed for the certified copy. Now, Your Lordship kindly sees the annexure A.
Paid for the certified copy. How could you prefer an appeal then?
No, no, Your Lordship kindly sees the notice.
How could you prefer an appeal?
Your Lordship kindly sees the notice whereby I am aggrieved. I was threatened to demolish. That is why the appeal was preferred against these notices.
Which notices?
Plus 10A page.
Against notice, the appeal is not maintainable.
They are
I am holding against notice.
Your Lordship kindly sees my Lord.
Holding against notice, appeal is not
Your Lordship
maintainable.
kindly sees my Lord 10A. The notice whereby the order
is not maintainable.
Order is, my Lord, directed. My Lord, this order is direction was made by this notice to execute the order.
Where is the
Now, Your Lordship,
where is your sanction plan, Mr. Bhatt?
Your Lordship kindly sees, my Lord.
Where is the sanction plan?
That is, my Lord, the subject matter of appeal. Your Lordship knows, my Lord.
Please show me the sanction plan.
Your Lordship kindly sees, my Lord.
Please show me the sanction
Your
plan.
Lordship kindly show.
I will allow the miscellaneous appeal. Show me the sanction plan.
Your Lordship kindly sees.
I will allow your appeal.
Nature of structure. Your Lordship kindly sees.
Not required.
Yes, not
show me that it falls within the exceptions. Show me that.
That is why, my Lord, the appeal is required to be heard. It is to be proved before the appellate.
Please show me prima facie for admission.
Your Lordship kindly sees.
Prima facie satisfaction. Court can look into that.
In that case, my Lord, I have to show Your Lordship the structure. I have to collect the my Lord.
Show me the structure. Show me the structure.
In that given, my Lord, I was under impression that against.
Have you yourself seen the structure?
No, no, I was not
seen that. Go. I am appointing you as a special officer.
No, Your Lordship kindly.
So please visit.
I will
file a report.
Your Lordship,
as to the nature of the structure.
I am not submitting
photographs.
I am not submitting from the record. Your Lordship kindly have a look to the application itself.
Yes. Who appears for Ranaghat municipality?
You know, the first time appearing. Your Lordship kindly.
First time appear. Who is appearing for the Ranaghat municipality?
Yeah.
I'm asking. Yes, yes, in High Court.
Usually, Lord, he appear for Ranaghat. I do not know, my Lord.
You are moving group 5 matters. You do not know who appears for which municipality.
No, Your Lordship kindly have a look to the, my Lord. Since no caveat is there, Lordship kindly sees, my Lord, Miss Appeal 2 of 2025. This is the appeal itself.
There is nothing wrong in this impugned order. I am holding that.
Kindly consider this thing. Your Lordship already.
From the Ranaghat municipality.
Your Lordship already passed so many orders with regard that during pendency of the appeal of municipal appeal, my Lord, no, my Lord, the demolition work cannot be carried out. At least the
appeal is not maintainable against this notice.
Your Lordship kindly sees my application itself. Your Lordship kindly have a look to
where
page D, page 18, annexure D. Till date, no order has been supplied to me. What else I could do, my Lord? Your Lordship kindly have a look to the notices. 2 consecutive notices were sent without even permitting me to participate in the demolition process. I do not know even that whether demolition proceeding has been initiated against me or not. Only Your Lordship can, if Your Lordship kindly sees the 10A on an inquiry made by our technical staff.
Yes, Mr. Chakraborty, who appears for Ranaghat municipality?
বসে যা উপরে যা তুই উপরে বসে যা
Who appears for Ranaghat municipality? Yes, I'm keeping it tomorrow. Please serve upon the learned advocate who appears for. Achinta Banerjee,
I think Achinta.
Kindly direct.
bring him. I'm passing it over. Come at 3:50. Serve him a copy, bring him.
Achinta Banerjee.
Yes. Yes, yes, pass over করে রাখুন।
No, ঠিক আছে।
3:50 রাখবেন এটা। Yes, next.
35. My lord, I beg to appear on behalf of the petitioner. I am the preemptor petitioner in this matter, your lordship. The opposite parties entered appearance, opposite party number 1.
What is the order which you are challenging?
2 orders I have challenged, your lordship. I am just indicating the opposite party filed an application challenging the maintainability of the preemption application.
On what ground? Short deposit?
No, not short deposit. That I am not the. All other points are taken. I am not a co-sharer in respect of the property. The entire share has been sold out. Notice was served upon me. I am a notified co-sharer. All these points have been taken, your lordship. But now on 20th August 2024, your lordship will find at page 19. I was.
What is the order under challenge?
My show. There was a direction to show cause.
What is the order under challenge?
December 11, 2024 and April 22, 2025. There are 2 orders. The first order, initially I was directed to show cause on 11th of December. That is
Give me a minute. Give me a minute.
I have not filed the show cause. I filed an adjournment application. So for the next date for filing the show cause and the written objection to the maintainability application. That was rejected, and on the page 20, the first part of the order I am not aggrieved. The second part on perusal.
So you have filed this application that the preemption application is not maintainable?
No. I am the preemptor.
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 Where is the application?
Maintainability, your lordship will find at page 15.
15. What is the ground taken?
Lordship, the first ground at page 15 is that entire share has been sold.
What has been done on this application?
That is already hearing has been done, and the date was fixed for passing orders on 14th. The presiding officer did not sit on 14th, and the next date was fixed today. I have taken instruction, your lordship, that till now no order has been passed, and she is probably not sitting today.
So how that affects your right?
But today, if the maintainability application has already been heard, if it is allowed, and without even hearing me, my entire preemption application goes. And only
you have a right of appeal.
No, but my contentions with regard to the maintainability, that is not brought on record. Nothing is there, and I could not even make my submissions because, your lordship, even if I do not file my written objection, I have a right of hearing on their application. That was also, there was an adjournment petition.
Rejected.
That was also rejected because the learned advocate was out of station.
This application of theirs may also be rejected upon hearing them.
If that is done, that's a different thing. But if it is allowed, I will be without any remedy.
14th of May, no order has been passed.
No, she was not sitting. Today is the date fixed. 19th was the next.
Today is the date fixed.
Yes, but no order has been passed, your lordship. I have taken
tomorrow.
Specific instructions.
See what happens.
Your lordship, may I come back with, because today probably she is not sitting as well. I took instruction.
Tomorrow, I am keeping it tomorrow. Passover kore rakhun. And not today kore rakhun. Yes, call the next matter.
36, my lord, I wait for the petitioner, my lord, an innocuous prayer for expeditious hearing of the Order 7 Rule 11 application.
And looking at the cost title, my lord.
Expeditious hearing of the application under Order 7 Rule 11.
Yes, what has happened, my lord, there was a direction of the Honorable
Let me come back tomorrow. Let me have a copy.
Expeditious hearing.
Lord, 711 filed just maybe a month back or 2 months back. The judge tomorrow is the date. The learned judge is on transfer.
Expeditious hearing.
Learned judge is on.
Mr. Chakraborty.
Let me see your expeditious.
Lord, there was the direction.
In your lordship's practice, like 300 pages expeditious hearing petition.
300 pages.
They have written. Let me check.
I've seen who've done that. I'm telling you, Mr. This is the punch of expeditious hearing.
Let me just.
This is the volume.
Your lordship, my lord, there was
the judge is on the learned judge is on transfer. He is last
my lord, kindly see the direction of the Honorable Court at page 52 once.
If there is a direction,
my lord, there was a direction to dispose of the injunction application.
Yes.
My lord, the injunction application was directed to be disposed of. My lord, they took out an Order 7 Rule 11 application. My lord, unless
Your lordship's copy is also like marked like this,
What mark like?
page 52.
No, your lordship's copy is.
Mr. Chakravarti, you are showing this. I will remember when your application
Yeah.
comes with this.
I recollect one matter. I was
No.
Justice,
My copy has not been marked.
Justice Korgupta, his lordship did not like that underlining and all
Yes, sir.
that.
My lord would kindly take page 52 once. My lord, there was a direction by this honor division bench.
Mr. Chakravarti, after all, your application, they are trying to
Yes,
expedite.
yes.
So you cannot be a aggrieved
Until
party.
judge is not transferred. Day after tomorrow is the date, kindly keeps it thereafter. If it is not taken, a minor passes the order. Because on the last occasion, what happened, both of us were there. The learned judge says, my transfer order has come, do not proceed before me. So 21st is the date. If he doesn't pick up, then minor passes the order. But now before transfer, this will be this order may be a pressure on the learned judge.
My lord, I am told.
This order will be a pressure on the learned judge.
Lord,
Let the plain dismiss rejected as early as
So that we have a good case. That's not an issue.
So I
But
think
this-
that will be
but
better.
before this,
If it is
he will not
rejected,
take up.
if it is rejected this side of the vacation.
He was
Mr.
only
Chakravarti,
saying that after 21st, my lord may pass this order below, he
this
will be.
application under Article 227 of the Constitution of India is that
my lord.
then it is to be reheard. Yes, next.
37.
Yes.
By the orders impugned, my application for temporary injunction has been dismissed.
By the order impugned, your application.
Temporary injunction has been dismissed. I am challenging the appellate order.
Yes. What happened in the trial court?
Trial court dismissed my application.
Trial court dismissed, appellate court also dismissed.
Suit has also been dismissed.
To dismiss.
I need not to say anything. 50,000 cost has been imposed upon me.
No, where is the dismissal of the suit?
That has been annexed. Kindly see.
Then you have to challenge the order of.
No, whether this order can be sustained or not.
But if the suit has been dismissed,
Suit has been dismissed, Milord. Whether appeal May 2025. Whether appeal court, whether Milord appeal court can order that if I do not pay 50,000 rupees as cost, my suit will be dismissed. That is the main question. Even high courts do not.
No, that is the miscellaneous appeal was dismissed.
Miscellaneous appeal.
Not the suit.
No, kindly see page 88. Kindly see page 88.
suit has also been dismissed. Whether even my lord High Court cannot order this. Today, if I am before your lordship in connection with a suit and I am supposed to pay some cost, if I do not pay the cost, the suit will be dismissed. Even this order High Court will not
Right,
pass.
you have to take steps. The suit
I
has
have
been
to- I-
dismissed. So what can this, how this application is maintainable?
Kindly see the order of the.
I appreciate maybe it's a wrong order, but the suit has been dismissed.
If the order, my lord,
Now you have to take steps.
I
Take all these points. I'm giving you that liberty.
No, my lord, one thing. If the order of the appeal court, my lord, is set aside,
Mr. Rai, there is no existence of the suit.
my lord, whether this order can be passed or not, that is the question.
For that, I'm giving you liberty. Raise all points in the appeal, or you have to file any other application as you so choose.
No, in that
Now the suit is dismissed.
see the order. my lord.
I've seen the order for non-compliance of the order.
Now see the appeal court's order.
Mr. Rai, even if
No, my lord, I
take steps, you file an application, take all points there. I'm giving you the liberty.
my lord,
227.
no, my lord, kindly see whether if the suit is dismissed, my lord, it should be, my lord, one decree has to be passed. Now kindly see the order. Page 88, my lord, kindly see the order. Kindly see the order.
Yes.
The instant suit be and the same is hereby dismissed
Yes.
for non-compliance of the order dated 3rd April 2025 of the Learned Appellate Court passed in Municipal 19 of 2024. Now, my lord, what is the order in the appeal? Appeal court, my lord, affirmed the order of the Learned Trial Court in
There is a
dismissing the
provision.
application.
There is a provision either
That
for,
is, my lord, I have
for
appeal.
either for restoration of the suit or for appeal. That you have to go.
No,
that.
now question is, my lord, restoration of the suit will arise if I deposit 50,000. Now, my lord, this order, the order by which he has been, my lord, or rather she has been prompted to dismiss my suit, my lord. If that order is set aside, my lord, this order goes.
What order is set aside?
If the order of the Learned Appellate Court.
Right. If there is no existence of the suit, whether an
That is
application.
illegal. Now, my lord, kindly.
Whether an application, give me an authority that 227 is maintainable.
227 is not maintainable. But, my lord, so far as the order of the Learned Appellate Court, kindly see the order of the Appellate Court.
Sir, how can I go when the suit is not there? That is what is troubling me.
That troubled me also, my lord. I initially thought that I would challenge that order also.
I will give you.
I cannot file 227 challenging, my lord, an order by which my suit has been dismissed. I cannot file 227.
When after the suit has been dismissed, even Mr. Rai, I did not tell this to you. Even if you challenge an interlocutory order passed in a suit,
yes,
then in a civil revision application,
yes,
let us assume the civil revision application is pending. In the meantime, suit gets dismissed. What would be your reaction?
No, my lord.
So
automatically
you have to prefer an appeal or
wait.
So all
Lord,
points are
kindly
kept open.
Visualize one thing. Kindly visualize one thing, my lord. An order has been passed on 3rd April asking me to deposit rupees 50,000 at cost. Now, my lord, what is the time? They must, my lord, give me the time to challenge the order. That is, my lord, 90 days. I could not have said anything if it was done, my lord, after 90 days. At least I should get the appeal period benefit. I should get that benefit.
I appreciate all these points, Mr. Rai, but the fact remains the suit has been.
She will not, my lord. Because the other suit, my lord, from the very first date, my lord, it proceeded ex parte. PW 1, 2, 3, my lord, completed. I'm not taking that suit here because that suit is not under challenge. Now, my lord, at least I should get the benefit of my appeal period. I have not given that time also.
Sir, I will leave all points open, raise all points what you are urging here, but before the appropriate forum.
Kindly record that.
Yes. By the হ্যাঁ কোন আগেরটা
Item number 38, my lord. I am being led by a senior milord. I am being led by a senior milord. In any ways, milord, this is for expeditious disposal of the execution petition, milord, filed before the commercial court at Alipur, milord. The execution petition was filed on 23rd of July 2024, milord, and thereafter no progress, milord. Notice were issued. Orders is at page 47, milord.
this application under Article 220. Yes, Mr. Banerjee.
For the petitioner, my lord, plaintiff petitioner, the suit for declaration and injunction, but I obtained an order of injunction which was extended subsequently on the 17th of February. I filed the application for extension. The practice of that court is that, my lord, normally applications are not called on. Your lordship knows, my lord, some courts, my lord, they call on the matters. In this court, my lord, previously it was extended without, my lord, moving the matter. On that day, my lord, suddenly order was passed that nobody is there. Injunction is vacated. I filed 151 application immediately stating that this happened. Kindly restore the interim order. That is not kept to date, not along with the main matter. 4th June. So my prayer today, I have challenged both the orders, my lord, that I filed the application. This was the practice, but I'll not press not the prayer against the, because it might become appealable. I know, my lord. Although it is not a technically order under rule 4.
Refusal, Mr. Banerjee, when you say I filed an application, though captioned as 151, but your prayer is to pass an interim order. Not passing, keeping it amounts to refusal to pass an interim order.
Order section rule 1-2 is passed. Now rule 4 is vacating. This is not a vacating under rule 4. The order was not extended. But that is also.
Now, when you want extension, refusal to extend means refusal to pass an interim order.
But so far as my prayer, I pray, my lord, kindly direct the court to hear out that 151 on the returnable date. Because
What is the returnable date?
Returnable 4th June.
Where is your 151?
151 is, my lord, at page 39. 39. I moved it, my lord, the court should have taken up because now, my lord, the opposite parties are entering into the property, digging the land. I obtained injunction, it was protected. I'm suffering.
Why don't you move the applications, Mr. Banerjee?
Now it was filed on that day, it was put in the Shia Khata, it was told that matter shall not be called on. Why shall I not? If I go, I file the application with the stamp, court fee, why should I not move the application? It was the practice, not the previous day also this happened. These are not, I cannot not say that, but this has happened. So if I filed the 151 with a request, it should have been taken up on that day. Purpose is to protect the property. Court will not fix the.
This application under Article 227 of the Constitution of India Purposely, I have avoided that expression.
For one mistake, we have committed a mistake. For that, they suffered enough on that day.
So now you have to do something before the learned trial judge. You have to appreciate what is the stage. Everything cannot be said
Lord,
from
can
here.
I well, submit this, my lord, that your lordship will, in the meantime, the opposite parties may file objection if any, if your lordship will not.
Don't do that. Don't do that.
That would be too.
That is why I have kept it at that. You are there because it's an.
And
Item number 34, your lordship.
Yes, call the next matter.
Item number 34, my lord, your lordship. Your lord directed me to serve Ochinto Banerjee, who is supposed to appear for Ranagat Municipal.
Yes, yes. Where is Mr. Banerjee?
He is, my lord, out of station. My clerk went there, my lord. He was out of station till tomorrow, my lord. He will not be available. Your lordship, kindly, my lord, I am, my lord, submitting.
I'm at 350. I've kept it at 350.
350.
350.
350.
41, yes.
41, my lord, defendant petitioner come before my lord against rejection of an application under Order 7, Rule 11, filed by this petitioner.
What is the ground of Order 7, Rule 11?
My lord, ground, my lord, it is interesting. Will was executed our father, sometimes 1969.
What is the ground? What is the ground? Which clause of Order 7, Rule 11 you are trying to invoke?
Order
A,
7,
B,
Rule
C,
11,
D,
4.
which?
D.
B. Failure to disclose a cause of action.
Not that. No, cause of action, na. Barred by law.
That is D.
Yes. D.
Under what law it is barred? Suit is barred.
Yes.
Under
my
what
lord.
law? Under what law?
Because, my lord, according to statement of the plaintiff, my
Under
lord,
what law I'm asking you? The suit is barred.
according to statement made by the plaintiff,
Yes, under which law? Under which law?
Order 7, Rule 11, my lord. D.
Sir, D says, if it appears from the statement made in the plaint that the suit is barred by law. I'm asking you, barred under what law?
Because,
as per the statements made in the plaint, the
because,
suit
my
is
lord,
barred under what law?
that's why, my lord, I am saying.
Give me a minute. Let me go through the impugned order. Please give me a minute.
My lord, kindly come to my lord.
Please give me a minute. Let me go through the impugned order.
Last part, 2 page. Observation of the court, my lord, kindly come.
That is exactly what the learned trial judge has said. We have not specifically stated on what ground the suit is barred.
My lord,
Right.
kindly come to my lord. My lord, kindly place me. Kind lord, allow me to place. My lord, kindly come to the first page of the order, last line.
Yes.
The defendants claim that the suit is barred by law, but has not stated specifically on what ground.
I'm asking you on what ground?
Yes, my lord. Now, my lord, come to my application. My lord, before that, my lord, kindly come to the plaint ones. My lord, plaint start at page 11. My lord, paragraph 10 of the plaint. That in the said will, the said Vijay Kumar Sarkar is the father of plaintiff and defendant, had bequeathed the premises 72A Pathuria Ghat Trustees, PS Jorabagan such and such, 72B Pathuria Ghat Trustees Jorabagan bequeathed to the plaintiff, absolutely and forever. Then, my lord, after grant of probate, executor of the will, Ajit Kumar Sabui, had executed deed of assent in
Sir, don't read the entire plaint. Please tell me what is the ground for rejection.
My
Please
lord,
don't read the
my
entire
lord,
plaint.
according to plaint, my lord, already plaintiff stated that will was executed, High Court granted provided, and according to the provided, two premises was bequeathed between two plaintiff and the defendant. Thereafter, in the plaint, he claimed 50% share of the property, which was already since 72, it was separate premises. It cannot be again partition. My lord, kindly come to
Where is the prayer for partition?
My lord, kindly come to the page 17
Yes.
of the prayer of the plaintiff.
Yes.
For declaration, plaintiff is the absolute owner in respect of 50% of the suit premises, that is, the land being premises number 72B Pathuria Ghata.
Where is the will? Where is the will?
My lord, will my lord start from page 21, that the order of probate. Then my lord, will start from page 26. Page 26. Relevant page is page 28, where it is stated that bequeathed the premises. Page 28 top. The premises number indeed at page 28.
Yes.
Page 28, my lord.
Yes.
Absolutely in premises number 6, Pathuria Ghata Street, then 72B Pathuria Ghata Street, Calcutta, to my second son, Gopinath Sarkar. That is the plaintiff. Then, my lord, slip over 4 line. I also give bequeathed my dwelling house 72A Pathuria Ghata Street, Calcutta, to my younger son, Ganesh Chandra Sarkar. Two separate premises. Then, my lord, after provided, my lord, kindly come to page 33. The deed of assent executed by the executor. That is in the year 86. This is for in the name of plaintiff Gopinath Sarkar. Premises number 20. That is premises number 72B Pathuria Ghata Street, bequeathed. Your lordship get at page 37, middle portion, 72 Pathuria Ghata Street, Calcutta. Then, my lord, another deed of assent executed by the executor on the same day as page 41 in favor of this petitioner. Executor was the son-in-law, elder son-in-law. It is in favor of Ganesh Chandra Sarkar, the petitioner herein. Then, my lord, come to page 47. Two separate premises, SSC number is separate.
72 Pathuria Ghata Street given to whom?
72A given to the petitioner, younger son.
Show me that 72A was given to the by virtue of the will.
My lord, page 28.
Yes. Which portion says 72A?
My lord, 2 lines from the top.
Yes, yes.
First,
Yes.
72B Pathuria Ghata Street,
Yes.
Calcutta, to my second son. That is
Yes.
the plaintiff, here the respondent.
And 72A.
And then my lord flip over 4 line.
Yes.
72A Pathuria Ghata Street, Calcutta, to my younger son Ganesh Chandra Sarkar. My lord got it.
72A. Yes.
To my younger son Ganesh Chandra Sarkar. And my lord, before that, page 27, the appointed executor Ajit Kumar.
So original premises of was 72.
Original was my lord 72. That was
how it was demarcated.
That was divided by the father when the father was alive.
Sir, I'm asking you how. What is the mode of dividing premises number 72 into 72A and B?
My lord, then my lord, I have to produce the plan.
So that requires evidence. For that requires evidence. So it has to go to the evidence.
My lord, kindly come. My lord,
Sir, initially the premises was 72.
I am putting it
Thereafter,
myself.
Thereafter, please, here I have gone through the plain. The plain case proceeds. Initially, the premises was 72 Pathuria Ghata Street. Thereafter, only separation was made by the corporation and two premises number was made 72A and 72B for the purpose of separation under the provisions of the Kolkata.
My lord, that is not. My lord,
that is the plain case.
That is plain case, but that is not the fact. According to my lord Prophet, that was demarcated. That was demarcated. After demarcation, it cannot be partition.
I am asking you how it was demarcated. Show me the.
Then I will show my lord. My lord, fix it
After,
anyway.
all right. After some argument.
Time date is fixed before.
Let the suit proceed, nothing will happen. Yes, next.
Minal Kanti.
Lordship, I am for the petitioner in this matter.
Yes.
Lordship, this is an application for expeditious hearing, Lordship. The application is pending for the succession certificate, issuance of succession certificate. This application was filed in the year 2021, Lordship.
Order 6 Rule 17 has been disposed of.
No, Lordship, they have not filed any objection. That is pending.
This application under Article 227 of the Constitution of India is at the instance of the parties. Yes, next matter.
In judgment data is the petition of your lordship. In a suit for eviction on the ground of default, nuisance, and change of use, others, etc. The revision and application is directed against an order, whereby my section 47, while adjudicating my section 47, it has been kept in abeyance, staying the operation of the execution upon an occupational charge of 12,000 rupees. When I say that the forum is quorum non juris.
Why?
But the issue is originally Kollol Dotto and Ashish Bardhan were the joint tenants. After the I am the widow of Kollol Dotto. After
Those are on
demise,
merits, Mr. Kormokar.
yes, but if
So
if it's
you deposit the occupation charges.
apparently it's on quorum non juris. Apparently.
Why?
Two suits have been filed against two tenants, claiming I am not a tenant.
Mr. Kormokar, that cannot be decided in an execution proceedings. Why did you not prefer an appeal for
But in
that?
section 47, I can take that point.
Why? Decree is a nullity.
Decree is a nullity.
Why?
Quorum non juris.
Why?
Presidency Small Causes Court does not have a jurisdiction to try a suit against a trespasser.
You are saying joint tenant.
Joint tenant was my husband. After my husband demise, joint tenancy, it cannot be substituted. Remaining surviving tenant.
Yes.
Against that suit has been filed. Against that tenant suit has been filed. That's pending.
Yes.
Again, a separate suit, subsequent suit has been filed against me, claiming me as a tenant. And ex parte eviction.
Claiming you as a tenant.
Eviction
Yes.
decree has been obtained.
Yes. So eviction decree has been passed treating you as a tenant.
No, that's
So whether you are a tenant or trespasser, how can that be decided in the execution?
prima facie, it's evident.
That you have to decide. That is on merits, Mr.
The reason,
Kormokar.
the other point is with respect to this is a 600 square feet shabby. I'm not even in possession of that.
Please break it. Shabby, don't stay in a shabby accommodation.
The
You are entitled to stay in a much more habitable accommodation.
court is kindly sees the fraud played upon the court. Suit is pending. 2010, he goes and files a suit against the original tenant. He fails to get a decree. He files a separate suit, not even impleading me in that suit. He files a separate suit in 2013, obtains an order ex parte.
You can apply for setting aside the ex parte order.
That's exactly what I've done. In section 47, I say, it's quorum non juris. Because from previous suits, there are
Mr. Kormokar, whether you are a trespasser or you are a tenant, that
Lord,
cannot be decided.
Kindly, seize the
So,
plaint once. Kindly seize the plaint once.
Maybe that cannot be decided here. Cannot go, executing court cannot go into the merits.
Section 47, if from the
No,
plaint
no.
I can disclose.
No.
I can demonstrate.
Not that.
So kindly
Cannot
seize
take-
the plaint once. Page 12. Kindly, page 12.
Where is the order of occupation charges? You pay,
Doesn't
I can,
No, kindly comes to the plaint first.
yes, which is the order under challenge?
Order under challenge, is 105 July 9. That your lordship would get at the last minute.
12,000.
12,000.
Pay 12,000.
Kindly seize the plaint once. From the plaint itself, I can demonstrate. Kindly seize the plaint once.
Yes.
Kindly comes to page 12, the plaint starts. Kindly turns over to page 14, para 4. That after purchase of the said premises and after obtaining the papers and documents.
Did you apply under order 9? This was the ex parte decree pass.
Party decree pass.
Did you apply under order 9 rule 13?
I immediately got to know and filed section 47. From the plaint, I can demonstrate.
So you are not challenging
Lord,
the decree.
I will. Lord,
If you will, please,
Lord, if-
because there is a limitation part also.
Lord, if section 47, I am successful, I can demonstrate.
Mr. Kormokar, section 47 decree remains as it is. You cannot challenge the merits of the decree.
Lord, if I can demonstrate from the decree itself, from the decree or the plaint itself, that Lord, the fraud has been played upon the court, Lord, the decree will go. Lord, kindly seize page 14 once.
That will be decided in section 47 application. Please pay occupation charges for the present.
So
For
12,000.
stay,
12,000,
or you need not pay. 144 is there. So once 47 execution The decree is set aside, will
Kindly
be
seize
restored
the,
back in,
Lord, kindly seize
will
the,
be restored back into possession, no difficulty.
kindly seize the ploy. Kindly seize the ploy. Not one premises, one suit premises against the tenant suit is pending. During the pendency of that suit,
You have
separate
a
suit
much
has been
better
filed.
case, Mr. Kormukar, you have a much better case in a regular appeal. You did not even file Order 9 Rule 13. You need not show that you was prevented, non-service, service. File a regular appeal. Very good case you have. Why are you going in 47? Challenge by filing of a regular appeal. You need not, then also the question of occupation charges may arise.
But occupational charge, whatever is there.
You
Lord,
can take that point that you need not pay any occupation charges. Appeal court can on the very same day allow your appeal.
Lord,
Because if this is the point, Mr. Chakravarti, Mr. Kormukar, appeal court can allow your appeal on the very first day.
that will never happen.
So it's you have a wonderful case on merits.
Never happens. Lord, kindly seize the suit premises once.
Mr. Kormukar,
12,000 rupees, Lord. 12,000 rupees in, Lord, even
you
the
pay, I will direct you to serve, it will be adjusted after fixing the final amount. But
some reduction,
no,
Lord.
not now. You pay, it will be
Even the
adjusted.
excess, Lord, is, I am
So it
told,
has been
Lord,
directed to be
some
paid from when? From when?
Lord, directed to pay to, Lord,
12,000 from when?
from the date of the decree.
When is the date of the decree?
Decree was passed, Lord, 2015.
2015. So you start paying from now. If it, some amount is reduced, it will be adjusted from there.
At least grants me some liberties. Lord, I'll pay the occupational charge for the time being. Kindly permits me to do that. For the time being.
Yes.
From this, Lord, month.
From this month, you will pay. Yes.
From
Do
this
that.
month. At least
Do
from
that.
this.
Do that for the present. It is however
preemptive the petition before your lordship. And my only necessary direction for expedition hearing of the title suit, which is to pending before the my lord, Lance Civil Senior Division.
expeditious hearing of this title suit.
Yes, ma'am.
What is the stage?
Actually, written statement was filed. Thereafter, my client filed an application 151 for rejection upon that to pay the
151 for what?
to pay the occupational charge it
During the pendency of the suit.
And
now this is being followed in every suits.
only my lord to prepare to expedite hearing of the suit as well as the application. Application as
Let
well
the
as
application first be decided. Because there is a chance of another civil revision application to come up after
actually, my
151.
should
This
for
applic-
my lord eviction right.
Position under Transfer of Property Act, the defendant appeared, filed WS along with application 7172 section 5 of, and thereafter, my lord,
Transfer of Property Act.
the suit was for Transfer of Property Act.
How 7172 is
I
maintainable?
don't know, my lord, but thereafter we filed the objection. They withdraw it by filing another 151 application. And the unfortunate thing is all these applications kept on record and no order. Kindly come to the my lord, 24th March 25, just go to the order, your lordship will understand. Today is fixed for filing WS 7172 under limitation of section 5 limitation act, hearing the application under 150. This 150 is for withdrawn.
Where is your plaint? Where is your plaint?
My lord. Plaint, my lord,
You have not annexed the
I've
plaint.
craved leave, my lord. I have the copy.
Yes, give me the plaint.
My lord.
Why do you say it's a Transfer of Property Act suit?
my lord, the rent is more than 9,000.
But you have framed your suit as that of a Premises Tenancy Act. Ground of default, ground of subletting, ground of
Notice has been written in that way. That's why it is
eviction
written, but
notice,
I think-
everything. So you have framed your suit as that of a Premises Tenancy Act.
But my lord, that will not overcome the statute. The
That is
statute
neither here nor there.
Applications be disposed of. Let the applications be disposed of expeditiously.
Application under.
For the petitioner, my lord, this is a little interesting matter.
This is
Little interesting, my lord. My lord, by way of the impugned order, my lord, the suit was relegated to the arbitration. The two, these evolutions. There was a caveat on the other side.
Yes, he is appearing.
Yes. Lord, in the year 1991, the plaintiffs and the defendant purchased a property.
No, what do you say that it should not have been relegated to arbitration?
There was not. There is a partition suit. There was no arbitration clause in the partition in the purchase deed. Two properties were purchased in 1991. They were amalgamated, and the building was constructed by the plaintiffs and the defendants. On a later date, after a few years, the plaintiff and the defendant entered into a partnership deed, unregistered. With the intent that we will let out this premises, we will let out this premises to somebody else, third parties, and we will realize the rent in the account of the partnership. That was never acted upon. Now we have sought the disputes and differences cropped up. We wanted partition of the property, private dispute. The matter was delegated to the arbitration. But there was an arbitration clause in the partnership. A partnership is a body corporate.
Where is the plaint?
The plaint.
Yes.
23 to 41.
Where is your application under section 8? Their application, where is that?
Page 140, it starts at page 154.
154.
This is the partnership with the arbitration agreement is annexed there. 157, the partnership agreement.
Where is the deed of partnership?
157
157.
onwards. 159 it starts. The relevant portion starts from 159.
Yes.
One thing falls for consideration. The property belongs to two individuals. The partnership agreement was entered into. That though it's a unregistered partnership firm, the partnership was entered into at a belated stage. There the property has to, because partnership is a body corporate. If the interest of the firm has to acquire an interest, the property has to be actually transferred to the firm. If the firm is not the owner, the two persons are the owner, they have sought for partitions only. But the arbitration cannot be referred to an arbitration because it's not a dispute regard to the business.
The partnership deed says that with regard to the letting out of business,
Not in
jointly
regard to-
purchase, that is the recitals of the
Yes,
partnership
but
deed.
the properties were never actually transferred to the partnership.
That is on facts.
But
How that can be decided in an application under section 8?
The property does not belong to the firm. The property does not belong to the firm. The firm is a body corporate.
May have been transferred to the partnership firm.
That transfer has to be there.
So so at the time of deciding an application under
There
section
should be
8,
one document, where the firm has become the owner. Only by a registered deed can the property of two individuals can be transferred to a partnership firm. Because the partnership firm is a body corporate. But there has been actual transfer to the firm.
I accept your submission. But
Two persons or three persons, there might be
whether-
other partners also.
whether there has been an actual transfer, whether the partnership business was commenced or it did not commence, can that be decided at the time of hearing of an
Let me say this,
application?
Let me say
I'm asking you, at the time of hearing of an
I'm
application.
answering. At the time of decision at the time of taking the decision in under section 5 or section 8, it should have come to the court, how the property has been transferred to the partnership firm. But there is no dispute in regard to the running of the business. The disputes are not touching the partnership firm, the partnership deed, No disputes are arising from the partnership deed. So there's a question of sending it to the arbitration does not arise. This is a private dispute. It has to be adjudicated, partition suit that has to be adjudicated by the court, This is the only submission. Has there been a transfer to the partnership firm?
Let me see. Yes.
Firstly, partnership firm is not a legal entity. No property can be held in the name of partnership.
What is to be referred to an arbitration? Please come to section 8.
Section 8.
Section 8 says which an action is brought in a matter. What is the action brought? Action is brought for partition. So at the time of section 8, whether the case of the defendant can be looked into or whether on the basis of plaint case it is to be decided whether it is to be referred to arbitration or not.
This issue has been settled by the Honorable Supreme Court in Vidya Drolia. The issue promulgated was whether the question of arbitrability is to decided by the court or the arbitrator when the dispute is referred.
When the matter as in a suit, as it seems from the plaint of the suit, it's a suit for partition.
It's not, May I just refer to the suit and the
Yes.
suit and the partnership deed in my own way, I'll not take more than 1 minute. Kindly have the plaint, at page 23 once.
All right, come tomorrow because I fixed one matter.
Very well. Maybe day after tomorrow.
Day after tomorrow.
I'm not here. Tomorrow I have a matter somewhere else.
They're all in the holiday mood.
No, day after tomorrow.
They're all in the holiday.
So I'm keeping it after the vacations.
There was an application for injunction,
Where?
Well, in the suit.
That time refused.
No, the interim application was being heard when the 5 and 8 came up. The matter was relegated to the.
Yes.
I'm not having an injunction order. That's the difficulty.
Injunction for what?
Changing the nature character of the suit property, and from collecting the rents or inducting new tenants. Or
don't transfer anything.
Just only that much.
But I will not transfer, but I am collecting.
I'm recording your.
Yes.
The Because after all, it's the tenant. Something has to be, otherwise the tenants will not pay anything.
Domino's Pizza is the tenant.
Yes,
Grateful. Grateful.
so you have been deprived from,
No, my lord, not all tenants. One tenant, we are paying them separately and paying me
no,
separately.
no, not the tenants. From the,
I would not say a word on that, my lord. I would not say a word. I'll refrain myself. I know where it is going.
yes, call the fixed matter.
34 minute, I am your lordship kindly have a look to the provision of section 218 first, your lordship.
Yes.
For the sake of your lordship kindly.
What does it say?
Your lordship kindly have a look to it.
Yes.
218.
West Bengal Municipal Act
Of the Bengal Municipal Act.
কেন এরপরের আর বই নেই আমাদের লাইব্রেরিতে একটুখানি 1993.
May I?
What is the date of your publication of book? Because there are some
18 amendment.
18.
18.
Yes, 218. Yes,
Yes.
please place that.
No, order for demolition or alteration of building in certain cases. If the Board of Councillors is satisfied that the erection of any building, these are, my lord, the provision Roman 1, 2, 3, B and C. If these are not been done, my lord, the demolition can be made. Now, your lordship kindly come to the next. It may, after giving the owner of the building a reasonable opportunity of being heard, make an order directing that such erection, alteration, addition, or projection, as the case may be, or so much thereof as has been executed unlawfully, be demolished or altered, and upon such order, it shall be the duty of the owner to cause such demolition or alteration to the satisfaction of. So, my lord, these things have not been happened. That is my submission. Your lordship kindly sees the notice has been sent directing me to demolish the my lord, the structure. Now I file the appeal and the application where I have categorically stated that I have not been invited in the application in the proceeding of the demolition, and also the order of the impugned has not been supplied.
Mr. Bonik, learned Don't demolish then. All right. কি বললাম? Also,
No. Only chairman. Municipal.
no complaint.
No complaint. Suo moto is doesn't initiate. No complaint.
It shows there is something. What is called the next matter?
Lordship, the defendant is the petitioner before your
Matter,
lordship.
short matter.
Very short matter. By the order impugned, lordship, the application for order 6 rule 17 has been allowed, lordship, before commencement of trial, lordship.
Has been allowed.
Yes. No, lordship,
File your written statement.
they are altering the whole cases and lordship will kindly come to the schedule of the amendment.
Then come tomorrow. Because,
Item number 53, both sides are present. Item number 53, my lord.
both sides, it will
both
be a
sides-
contested matter.
No, my lord, it will be disposed of right now.
How?
Because my lord, there was a direction of my lord that there will be stay of the operation and there is a direction to produce some document. My lord, from the document, my lord, there is nothing. So my lord, I am not standing in the way if that their amendment is allowed. My lord, kindly dispose it of. And my lord, the interim order granted earlier, kindly be vacated. And my lord, I'm humbly paying, my lord, kindly expedite the suit, my lord. That is my only pay.
Who is for the petitioner? You are for the petitioner.
53.
দিন তাড়াতাড়ি দিন ফাইলটা।
My lord's order dated 25th April 2025.
So the written statement has been amended.
It is
That was allowed.
That was allowed. Well, I'm not standing in the way, kindly.
This application
My lord, interim order granted earlier shall be vacated. Interim order was granted earlier.
If the application is
My lord.
disposed of, the interim order will remain.
Lordship, item number 48, Lordship, it's a short matter, Lordship, and the other side is also there. Will you kindly appreciate, I'll not bother you, Lordship, kindly appreciate one thing.